Good morning. Thank you for being here so early this morning. You're here at the NSBA's Legal Skills Institute, and I'm here to welcome our first speaker, Susan Reff. She's with Hightower Reff Law in Omaha, and she practices in the areas of criminal law, DUI, juvenile delinquency, child abuse and neglect, and family law. Prior to co-founding Hightower Reff Law in 2012, she spent 7 years as a deputy public defender for Douglas County. She graduated from the Creighton University School of Law. So Susan, thank you so much for being here, and I will let you get to it. So here's the little clicker too. Got it. And then if you want, she showed me that. Okay. Yep.
Okay, good morning. If at any time you can't hear me, just raise your hand, wave at me, jump up and down. I'll try to accommodate as much as possible. And if I need to put the other mic on, I will. Thank you, Sarah, for having me, and thanks everyone for being here. I think this is the most exciting topic that I could talk about, and I'm going to try to be fun with this and try to be a little lighthearted, and at any time I would welcome questions, comments, stories. So first of all, I think we need a little buy-in when talking about both delegation and timekeeping, which is the next topic I'm going to talk about. But I think there's three things that we all have in common and kind of frame some of what I'm going to talk to you about and tell you about. And the first thing is, I think as lawyers and legal professionals, what we all want is we all want to have happy clients. I think we can agree to that. I think we can also agree that as attorneys and people who work hard, we all want to have a life outside of our law office, and that, you know, that's always easier said than done, but I think that most of us want that. And I think we all can agree we want to make more money. So I don't hide that. I don't think anyone should hide the fact that, you know, we want to be successful people. And one measure of success is making a little bit more money. So I kind of keep those three things in mind when I'm talking about both delegation and timekeeping. So first of all, can I ask if there's anyone in the room who oversees or manages other people? Just raise your hand. I do. How many people oversee or manage 5 people or less? Okay, how about 10? Okay, so we're all kind of small offices. All right, so perfect. So we're all kind of in the same world. I am first going to talk about what is delegation, and then I'll talk about why delegation is good. I'll talk about who is a good delegator and some traits that good delegators have that you can look for in yourself. And I'm going to talk a little bit about what I call the excuses, or the nice word justifications, that people use when they don't want to delegate or they feel uncomfortable delegating. And then just a brief little how to delegate to help people understand the steps of delegation. So let's see. All right, perfect. What is delegation? Delegation is a transfer of responsibility. What does that mean? It's transferring what you're doing to someone else. It's the ability to say, I have this responsibility, but I'm going to transfer that to another person. I think that's pretty obvious. Delegation is also a tool, and I like to always think about tools as a practitioner. What kind of tools do we have that make our lives easier, make our jobs easier, and lead to those three things we talked about at the beginning? So delegation is a tool to allow you to function with limited resources. What do I mean by limited resources? Well, we live in a limited universe, and the limited resources that we as attorneys have is we have limited time, and time can be, you know, we have 8 hours in the office a day, or we have a deadline of tomorrow at noon. That's a time limit resource. We also have limited knowledge. Hard for us as attorneys to admit that we don't always know everything, but we do have limited knowledge because no one can know everything. And so using delegation allows you to overcome some of those limitations on your resources. So what are some ways we can delegate that are out there? Using automation is a way of delegating. And what do I mean by that? Well, an example that my office just instituted that was a delegation of a responsibility from me to an automated system is we instituted a time clock. We didn't have a time clock before. I was keeping track of everyone in the office's hours for our hourly staff. How much time did that take? Well, in the summer when everyone's taking vacations, it took a lot of my time to manage that. So now we have a time clock that's doing it. Great, I'm not doing it anymore. Outsourcing is also delegation. This is probably my favorite method of delegation in my law office because I know I don't know everything. So this is a very easy way to delegate. Some examples of outsourcing as delegation are using a CPA to either keep track of your monthly expenses, to do your taxes at the end of the year, anything like that. Another example of outsourcing as delegation is using someone to help you with your marketing, using an IT professional. Certainly that's an area that I need a lot of support in is IT, so we have an IT team that helps us. Another way is using technology. An example of this would be using billing software, not using hand-written timesheets, using a software program that maybe has an app. Also using a client management software program is another way to consider technology as delegation so that we're not using paper any longer. So why delegate? Again, like I said before, no one person can do it all. I think this is a thing that as attorneys and as hardworking people and people who hold ourselves to high standards, we think we can do it all. But really, in the long run, I think if we loosen up on this expectation for ourselves and utilize people on our teams and who can support us to delegate tasks to, we can actually probably do more. And on top of the no one can do it all idea is the no one can know it all idea. So remember, using outsourcing as delegation, no one here probably is a CPA, also has a marketing background, and is completely up to date on the latest IT issues that lawyers are facing, and then on top of it can manage a caseload and an office. So knowing that we don't know it all and can't do it all is the first step in then using delegation and using a team of people to help us get to where we need to be. So now why delegate? Well, going along with those three things in the back of our mind, also think about delegation as an opportunity to teach, to mentor, and to expand the capability of your team. So in teaching, delegation is an opportunity to teach your staff, to learn from you if you give them the opportunity to do some of the work that you are doing. It's an opportunity to mentor. Maybe a senior or a more experienced attorney has the opportunity to teach and mentor a new attorney or a paralegal or legal assistant in a way on a topic that maybe they don't have experience with. Delegation also offers you the ability to expand the capabilities of your team members. This is important, I believe, in staff turnover. And if you're managing people, one of the hardest things I believe to do is hire and fire. So if you have less turnover and you have your team feeling fulfilled, doing work, assisting you with your work, you're going to minimize staff boredom and then ultimately, hopefully, staff turnover. Why delegate again? Increases efficiency. So what does this do? This helps you focus on the tasks that require more of you. We'll get into a little bit more of that in a moment. Why delegate? It removes the busy work. In a law office, there are many tasks that are repetitive and boring and that happen every single day or every time you do something. Like every time you file a motion, these 4 steps need to take place. Things that need to get done but do not need you to get them done. You can delegate those tasks to someone else and free up your time from those busy work tasks to do more major tasks, or like I said before, more tasks that need more of you. Additionally, delegation encourages collaboration. There we go. Work is more enjoyable if you aren't doing it by yourself. I tell you, I know an expert in this area. He's 7 years old and he's my son. You ask him to go do something, he doesn't want to do it, but if we do it together, he's much more likely to do it, no matter what the task is, right? Also, collaborating on tasks makes it much more likely that if there's a mistake, it will get caught early on, or innovative ideas will come about through collaboration. So this is my really, really silly attempt at PowerPoint, and you'll see on my next one that my skills get a lot better. But why delegate? It gives you the ability to take time away from work. And this is a photo of my husband and I in Seattle, where we were both able to take a little bit of time off from work. And that's because I think I've become a fairly good delegator. I do have the ability to take a vacation every now and then. So I wish everybody could do that, because then we go back to those 3 things we talked about before, and one of which was we want lives outside of our offices, right? All right. So who are seasoned delegators? Who's really good at delegating, or what kind of skills do delegators have? Seasoned delegators have good communication skills. They're able to communicate what needs to be delegated and how it needs to be done to the person they're delegating to. Seasoned delegators are good listeners. They're able to listen to problems people bring to them, especially the people who they've delegated the tasks to. Seasoned delegators are able to teach and train others. We talked a little bit about that. That has a lot of value in a small office too. Seasoned delegators have trust in the delegatee. So think about how your staff would feel if you gave them a task to do that they've only seen you do. They've maybe worked in your office for a year and they've always seen you doing something. And then you say, I'm going to pass this responsibility along to you now because I trust that you can do it. People want to feel appreciated. They want to feel like they're needed. They want to feel like they're an important part of the office. So a good delegator has that trust in the people they're delegating to. A seasoned delegator is able to give constructive feedback. No one learns unless they're told what they do is right or wrong. Feedback is important. Seasoned delegators are also effective time managers. So this is a good segue to the next topic, but think about how much time you could free up if you eliminated those busy work, repetitive, boring tasks to do the bigger tasks that we as attorneys have to do. So this is a quote I found on a law blog, and I want to focus on a little bit about what it says about attorneys. It says that attorneys, I'll jump to the middle, have high skepticism and low resilience, drive a deep status quo bias, and orient lawyers' issue-spotting prowess towards resisting change. The other traits that separate lawyers from the general population: autonomy, sociability, and urgency. And I think these are important in talking about delegation, these 3 traits. First of all, autonomy. And some of these traits, I think, are also strengths that we as lawyers have, but some of these strengths can dampen delegation. Autonomy, meaning lawyers prefer to maintain control. Sociability, and I'm not super happy with the sentence I typed in here, so as I was reviewing this, I might rework this, but lawyers either, I think, are very social or are very independent, not as social people. So I think both of those can play into delegation really well. But urgency, lawyers want it done now. And that's part and parcel because we have a judge to answer to sometimes. We have clients to answer to. We have opposing counsel to answer to. So we want things done now. So here's the excuses or justifications for not delegating. Let's talk about autonomy first. How many times have you heard in a law office or any office when talking about giving a task to someone else or delegating, well, I can do it better. It won't get done my way if I give it to a paralegal to do it. I've always done it this way. We hear that a lot, and that goes back to resistance to change. I think that's a human nature thing. Change is hard. Well, if I delegate it, I won't meet my own billable hour requirement. And if someone else can do the task, maybe I won't be needed. So I think a lot of these things go back to that trait of lawyers want to be autonomous and put your ego aside a little bit, delegate a little more, and honestly, I think your autonomy will actually grow if you can be a good delegator. So sociability on some excuses for not wanting to delegate. I don't like doing that, or I like doing this kind of work, so why would I want to give it to someone else? I like opening the mail at my office. No, I don't. I don't want to be perceived as incapable. I don't want to give up work to someone else because I don't want someone to think I'm not capable. Nobody wants to seem incapable, but it's amazing how capable you could be perceived when you teach your entire staff how to do something that you can do. So another justification with the urgency part, I can do it faster. Well, maybe the first time that you teach your paralegal how to e-file, yeah, you're going to do it faster than they will, but after that, they'll be able to do it faster. They'll probably develop a system where they e-file 3 motions in the time that it took you to e-file 1. And they're going to be doing it more often, so their skills will stay sharp if you give them the task. It takes too long to explain to someone else how to do it or how I want it done. If it is a repetitive task, you'll save more time explaining to someone else how to do it than you doing it yourself. So I added this one because I hear lawyers saying this all the time. I don't want to hire staff because I don't want to pay for it. I don't want to use technology because I don't want to pay for it. The perception that these things cost a lot of money, I think is dead wrong. You can't afford not to. You have to use support staff in some way, shape, or form. And maybe it's starting small, hiring a part-time person or hiring someone just to answer your phone if you're a solo. Using technology, there are a lot of free and reduced price programs out there. There's also a lot of programs that offer free initial trials. Most of the programs we use are based on a per user fee. So there's 0 to 5 users or 1 to 5 users is a certain price, 6 to 20, those types of things. So the I can't afford to, I think can only sustain for so long. People say I can't afford to have a CPA prepare my taxes at the end of the year. Well, guess what happens when the IRS catches a mistake and then you're dealing with them for 15, 20 hours to complete that. That's 15 or 20 hours of billable work you could have been doing or a vacation you could have taken. So the cheap, I can't afford to delegate, I think is one that where you have to put your priorities in a reverse order. What's more important to you? Okay, how to delegate. This is the meat of it. First of all, in delegating, there has to be a task or a project, obviously. Knowing what it is. So make sure the person you're delegating to has that information, the overview of what the task or the project is. Then, what is the end goal? Where are we trying to get to? Are we trying to draft a certain document? Are we trying to settle a case? Are we trying to implement a new policy in the office? Something like that. Who will be working on the task or the project must be identified. Are you giving it just to your paralegal, or are you giving it to a paralegal and an associate attorney? What's the time frame? When we talk about timeframes, I think sometimes people don't know when they're supposed to even start a project. They get the information and they don't know, should I start now? Well, my deadline is 2 weeks. Do I wait or do I start now? Identify who will be assigned to each step of the project and why. So I think the why is very important, and I've learned this from feedback from my own staff. No one's a robot. No one likes to just go to work no matter what level of employee they are in your firm and just do work. When you explain why you're doing something to your staff, they get some buy-in and they feel more important and they feel differently about the task than they would if they just are told, please file this motion for me. If you tell them why you're doing it, they also start to gather an understanding of the case. Maybe they don't know very much about that case or how the system works. If you say, let's e-file this motion or let's hand file this motion, maybe you have a reason why you're hand filing a motion versus e-filing it. And if you let them in on those things, you're building that trust with your staff as well. Next, how to delegate. Make sure the specifics of the task and the project are clear. So expectations are clearly given. This is an ongoing thing that I'm working on in my firm, is making sure I'm always clear. I think as lawyers we have probably 3 to 4 different cases running in our head or more at a time. We know where we want to get on a case with the project, and we're saying, okay, well, let's get this motion drafted and filed. Well, what does that mean? Do we want the paralegal to just begin the project for you, or do we want them to draft the whole thing and file it? Do we want to have people review it before it's filed? Do we want them to have the client review it before it's filed? Or is that something we are going to do? So making sure that the expectations and the details are very clear is very important in delegation. Because remember, you're giving this to someone that looks up to you as a more senior person. They may not come and ask you for questions. So you've got to be very clear to begin with. The action plan of the delegation or of the task. When to start, I talked about that a little bit before. I sometimes delegate and say, don't start on this yet because I'm waiting for this one piece of information that will fill it in, but now is when we have an opportunity to talk about it. So I want you to start it when I get the email from the client with that piece of information. How the delegatee should communicate problems regarding the task. So if there is a problem, if they get stuck on something or something doesn't look right to them, how should they communicate to you about that? Should they email you? Should you set up another meeting? Do you have an open door policy for those types of things in your office? Whatever it is, as long as you let the person know that you've delegated the task to, how they can approach you. Intermediate deadlines. So you may be filing a motion and you don't know when you're going to set it for hearing. Maybe you've contacted the bailiff and you haven't heard back. You could set an intermediate deadline of, well, let's get working on this project, but if we don't hear back from the bailiff by Friday, you're going to call the bailiff and follow up on that. That's an intermediate deadline in the task. When is the final deadline? This is very important, and I have learned to not say things to my staff like, let's get this done in 2 weeks, or let's get this done by the end of the month. I say, let's get this done by August 1st. And our case management system allows us to calendar tasks with deadlines. So even if we talk about it, even if everyone's taking very, very good notes, I always make sure that I delegate to someone who's working on the task with me to enter it into our system. That way there's a follow-up, and that way there's also a communication space for us to talk about the task. And then how will the final project be presented to whomever it's going to? Is it going to come back to you as the attorney? Is it going to be a letter drafted to the client? Because oftentimes I feel, especially with documents that are going to go to a client, that once it's done, no one knows what to do with it. Is the paralegal going to email it to the client, send it to the client, have a phone call with the client about it? So how are we going to take the final step here? And on top of that, is the attorney going to review it before the client does? Is important. Not everything needs attorney review, but some things do. So we have to make sure that we're clear on that. My last slide is my happy place, the beach. So I'm just putting this up here again to remind everyone about why delegation is important, why it's a good idea to try to become a better delegator. It is a skill. It is not easy. I don't think as lawyers we are wired completely to do this all the time. The more you do it, I promise you, the better your life will be. Your career will open up. You'll have more time to do different things, like go to the beach or where your happy place is. So I promise you my next PowerPoint is going to be a little bit more exciting because this one I did first and my skills got better because I don't think I'd done one since law school. So thank you for listening. If anyone has questions, comments, wants to talk about a horror story or a good story of delegating, I think we have a little bit of time left. And I was going to, oh yeah, go ahead. You're asking, is there a warning sign? Right. So the question is there a point or is there a warning sign when you realize maybe you've delegated too much? I think there could be, I have not had an experience with this, but I could see where if you're delegating and a staff person or someone takes it too far and almost takes over, is that kind of what you're getting at? Yeah, that could happen. A good rein-in might just be to have a sit down with that person and say, you know, I always start with the strengths, you know, wow, it's great you've learned this and you've mastered this task clearly because you understood what you were supposed to do, but there was a stopping point. And the stopping point was, you know, you drafted the letter. It was up to me to review it and send it to the client and not you to just send it to the client for review or something like that. That's like a good problem to have in one sense. I think if you can manage the employee after that. Yeah. Anything else? All right. Okay. As you will see, my PowerPoint skills got way better. I tried to delegate this task to someone in my office. I really did. This is funny. I said, if I write everything down, to two people, I said, can one of you make a PowerPoint? And one of them said, nobody uses PowerPoint anymore, Susan. And I said, oh, well, what do they use? And she told me some program. And I said, well, if I write it all down, will you do that for me? And she said, I don't know how to do that either. So I fumbled my way through PowerPoint, and this one I did second, so it got a lot better, and I had a lot less fear of just clicking away. So let's talk about how you use your time. I was asked to speak about timekeeping, and I wasn't sure if that meant more timekeeping, time management. So I'm going to talk about both a little bit. And let's keep in mind our three things that we talked about before, right? We all want happy clients. We all want a life outside the office, and we all want to make more money. And I think having good timekeeping skills and being a good time manager help with those three things. So that's why I keep those in mind. Here's a good quote that I found from Entrepreneur Magazine. 20% of your thoughts, conversation, and activities produce 80% of your results. So not a lot of what we're thinking about is producing the majority of what we are actually doing. So what happens to the rest? You know, how do we harness that? How do we make that 20% more? So what's the difference between timekeeping and time management? Timekeeping is more, how do we keep track of what we're doing with our time? Reporting the time that we spend on things. Time management is, how do we control our time? And do we have control over our time? And I'm going to confess something to everyone here, and this isn't as secret. I have no inner time clock. I don't know if you have ever represented anyone on a DUI, but one of the field sobriety tests is to sit quietly and tell the officer when you think 30 seconds have passed. And apparently that's a function of whether you're under the, or that's an indicator of if you're under the influence or not. I couldn't do that completely sober after a good cup of coffee and a good breakfast. I have zero, time clock, which is why I'm a very good traveler, because time changes don't affect me either. So I really need to make sure I have good skills in these areas because I do bill per hour. So why have good timekeeping? Let's talk about that first. Keeping track of your time actually helps keep you on task. If you know you're going to have to write down how long it took you to do something, the chances of you straying from drafting that memo that's on your desk to some other thing that distracts you, your cell phone, someone in the office, the internet, whatever it might be, if you know I've got to write down how long that took me, and that's going to get reported to someone else in my law firm and my client, and maybe even end up on an affidavit for attorney's fees, I want it to be accurate. Helps keep you on task, and therefore in the long run leads to higher productivity. So if I know I have 2 hours to draft a motion, and it's probably going to take me about 2 hours, if I'm setting a timer during that time as well, I'm less likely to stray from that task. And remember, we all want to make more money, so we all want to be accurate. Time is money. I think in everybody's world, time is money, especially attorneys, no matter if you're billing per hour or if you're billing at an hour or a flat rate. Accurate timekeeping will make you more money. In my office, we did an audit of one person's timekeeping. In 1 month, we found $3,500 of lost income. So, and that was at someone who, it was at someone who was billing $125 an hour. So that was a lot of hours. How to use technology, billing software, billing apps. The timekeeping program my office uses has an app that you can put on a tablet, on a phone, use remotely. We were finding that we were doing pretty good at keeping track of time, except for time in court. Why? Because it was on our desktop, and when you're done in court, what's everyone feel? Relief? Thank goodness that's done. Or now I need to go back and communicate to someone what happened. So if you have it on your phone, you might be more likely to enter that time. I think a tip on this that is very useful is to enter your own time. This is not something you should delegate. I am all for delegating, obviously, most things in the office, but don't have someone else enter your time for you. A, it wastes their time, and B, the chance of it not being accurately entered increases. No matter how good of notes you're keeping on your time, they may not enter it correctly. Or if you're thinking, well, I was in court for an hour, and you tell them that, they may think in their head something differently and record something differently. So enter your own time. Talked a little bit about this, using a timer. It seems really old-fashioned, right, to use a timer, but every smartphone has a timer. I have a timer app on my computer that has nothing to do with my billing program, but my billing software does have timers on it, and I can set timers for multiple tasks on my program. So if I do need to work on a motion and then I want to take a break from it because it's bogging me down or I feel I'm stuck, I can stop that timer and I can move on to drafting a brief and set another timer. Like I said, cell phones have timers. My office phone has a timer that actually, the timer part keeps good time. It just doesn't keep accurate clock time. So if I'm on the phone with someone and we're chatting about the case, it's keeping time, and right before I hang up, I always look. How long was I on the phone with that person? I think people tend to either be an overbiller or an underbiller, one way or the other, and that is not due to any motivation on their part. I think, like I said before, people's inner time clock is maybe not very accurate, and I don't even have one. So with timekeeping, contemporaneous time recording is a must. Billing right when you do something. I read a study that said 10 to 20% of the time is lost by not billing contemporaneously. You have to train yourself to do this. This is not easy for me because I like to try to get a lot of things done in a day. So I have to remember when I am done doing something, I need to then, I'm not done until I bill for it, until I go into my time management software and I enter what I did, how long it took me, and hit save. Just make that part of your routine to bill before you move on to the next task. This is a good tip that I'm starting to do in my day, is to review your time entries at the end of each day. This is where you can say, well, what did I do first when I got here in the office? Did I bill for that? Did I bill for that court hearing that I went to that, yeah, it only took 30 minutes, but it needs to be on my in my billing program. The other thing you can do is compare your to-do list or your calendar to what you've billed for the day. You're more likely to spot any mistakes or missed things while it's fresh in your mind that day, and then you can move on from it. And if you're working on a project that takes multiple days and you're billing a little bit every day of the week, if you're checking every day, then you're less likely to, I find, underbill for that time, as opposed to just saying, well, I'm writing this brief at the end of, I finish it on Friday. It was a 10-page brief. I'm going to guess that each page took me an hour. I'll bill 10 hours for it. Well, maybe not. Maybe page 3 was the big argument that you had, and that's the one that took the most time and the most research. And you want to bill more for that, the day that you spent on that one. So reviewing at the end of each day is a good tip, I think, as well. Time entry should be detailed. Your clients pay you a lot of money for what you're doing. You're offering them a service. And it is hard to justify what we do for clients because we don't go to the shop and make something and give it to a client. We don't go into their home and repair something and say, look, I fixed it. Now pay me. So in my office, we have instituted a policy where there are no abbreviations allowed on our invoices because they go directly to a client. They don't need to try to guess what MTN means. I think we all know that means motion. They don't need to guess what OBJ means. We all know that means objection, but our clients don't. They might not even know what the word objection means, really. But if we're spelling it out, it's more fair, and then we get to that number one thing that we're thinking about is we want happy clients. Additionally, no abbreviations and clear bills. It's harder for a client to complain about the bill or have questions about a bill. Or if your bill becomes public with the Council for Discipline or your malpractice insurance carrier, think about how much easier it is going to be to say, that letter I drafted on my invoice, it says draft letter regarding insurance claim on roof. How much easier is that to justify and jog your memory about what was happening than if it just said letter or LTR? So no abbreviations, lots of details in the long run will help you and help justify the time that the clients are paying you for. Let's talk a bit about time management now. Oh, cool, I didn't even know little guy was going to run. So, yay, me. Time management. So this is how to use your time. I think a good tip that a lot of people will tell you is know the time of the day that you're the most productive. Figure that out. Is it first thing in the morning? Is it right after lunch? Is it right before you leave? At the end of the day? And schedule the tough things for yourself to do during that time. I am most productive, in my opinion, about 10 o'clock in the morning. It's not right when I walk in the office because I generally feel that's a good time to check in with everyone in the office from the day before. And then I find that my phone rings a lot from about 2 o'clock till whenever I leave. So trying to schedule time to hit that brief at 2 o'clock in the afternoon isn't going to happen. So figure out when you're the most productive, when your flow of your office gives you some downtime also is important. This is a skill that I've been working on in the last couple of years, is schedule everything on your calendar, everything, not just the client appointment and the court hearings. Schedule when you're going to work on that brief and put it on your calendar. I don't know in your office if you share calendars with anyone else, but everyone in my office has access to see my calendar. And if they see that at 10 o'clock till noon, I'm going to work on the brief for the Jones case, they're not going to schedule anything for me, and more than likely they're not going to bother me, even though I have an open door policy. If you do need to close your door, schedule that. If you need to say, I'm not going to take a call, I am not going to take what you deem as an emergency for the next 2 hours so I can work on this brief, schedule that time as uninterrupted time on your calendar. And then for me, when I do that, I put on my calendar uninterrupted time, and I make a note of what I'm going to work on for myself. That keeps you on task as well. I also schedule appointments for me, appointments with yourself. What are those? What do I do with that time? Well, I have probably a stack of, at any given time, 10 to 12 law practice management articles I want to read, new Supreme Court opinions I want to read, things like that I need. I also sometimes find that in a more complex case, I need that time to process what's going on in a case. I do some criminal defense work, and there are times when I've got a motion on file and I've got videos. I've got an interview of my client. I've got a video from the police from a body cam. I've got an interview of the co-defendant implicating my client. And I've got to process through how all of those things play together. And that's what I like to just block off time to think about a case. Time management tip, make a to-do list. It seems really elementary, but I have 2 to-do lists going in my office at all times. I have a white legal pad and I have a colored legal pad. I can't get my office to just buy one color because they come in a multicolored pack, so it's white and colored. The white legal pad is my cases. Any client work I need to do, I put it on my to-do list. We have bi-weekly case staffings with support staff. I write on that to-do list what I need to do, only what I need to do. But sometimes what you need to do is check in with your staff, so that needs to go on the to-do list. And the colored legal pad is the things I need to do around my office, because I think those are separate and they require different amounts of brain power. So when I have an office task I need to do, like we were implementing this new time clock in my office, that was all put on my colored legal pad. Prioritize your to-do list. When you're sitting in a case staffing, we just go through the cases alphabetically, but that's not the priority, right? So I need to look at which case has a deadline, what do I need to do first, and number it. Update your to-do list frequently. How fun is it to cross off things on your list that you've done? And I take a lot of joy in that, and I think other lawyers do too. We're all a little bit maybe OCD, a little neat freak, all of those types of things. My favorite thing is when I get to tear the page off because I did everything on the to-do list and put it in the recycle bin. I think for me, what a to-do list does is it keeps my ideas organized, because I think we can have idea overload, especially on a case with a lot of moving parts. I generally look at my to-do list every morning, my caseload to-do list, and I think of one thing on there that I really don't want to do. You know, I have to make that phone call to that client and maybe give them some bad news or tell them, you know, we didn't think we were going to have to file that motion, but we're going to have to, something like that. And I do that first. I prioritize that as number one. And then I look at the list and I think of something that's really easy or really, you know, a good thing, and I'll do that next. And then I'll go back and I'll do a difficult thing. And then I go back and forth like that. Some people really like to stack the tough things and just get them all done and plow through. I like to go back and forth, but everyone's different, whatever works for you. But I think getting that one thing done, and sometimes I know we all have a to-do list in our head or written down with 3 things on it, and you think, man, I have all day, I'll get all 3 of those things done, and at the end of the day you got maybe started on one of them. And how does that doesn't feel very good, does it? But it happens. So if you get that one really bad thing done that you didn't want to do, the feeling at the end of the day of accomplishment is a lot higher. So I'm going to end on this quote from Henry David Thoreau, who I love, who I think is very much about mindfulness and the getting out of the office more. It's not enough to be busy, so are the ants. The question is, what are we busy about? So don't waste your time. Thanks, everyone. If anyone has questions or tips or concerns about timekeeping, I would love to talk about it. Yeah.
I have a question. My name is Caitlin Gering. I'm a criminal law instructor at Creighton Legal Clinic.
Okay.
And my practice background is all in nonprofit legal services. So I don't have practice billing in the private market, but this academic year, one of our goals for the clinic is to teach our students basic billing practices. So that was one goal of my attendance today, is some feedback about the best way to do that, or how, you know, first year associates are trained in billing, and what you can bill a client for versus what you can't, even if it's
Right.
you're in the office in achievement of client's goals or working on their case.
So the question is what tips on training new associates on timekeeping and what you can and can't bill for. I'm going to jump to what you can and can't bill for, because I think that depends. In my office, we bill for everything, and that's what our fee agreement says with our clients, is that we will bill you for phone calls, we will bill you for emails, and what we bill as a minimum, you know, 0.1. We don't do 0.05 billing. And I know there's some attorneys that have other minimum, you know, some attorneys say my minimum is 0.3 or 0.5 on a bill. I think ethically you have to tell the client what you're going to bill for and what you're not going to bill for. Our fee agreement specifies everything we can think of on that type of a case: drafting letters, attending meetings, attending court hearings, phone calls with opposing client, phone calls with the judge or the bailiff, phone calls with the mediator, all of that. I think you can't go wrong being overly broad in everything that could happen on a case to say, these are things we're going to bill you for, if that's the policy. I think you're much better off if you're clear. I'm going to bill you for this time. Some attorneys don't bill for phone calls, if that's in your fee agreement, but maybe you bill for emails or client meetings. When we make a mistake in my office, we don't bill for that time. When we draft a motion that we don't end up filing, we generally don't bill for that time. If we end up not filing it for a reason that was dictated by the client, like, oh, well, I guess I changed my mind at the very last minute, then maybe we'll bill for it or cut it in half. But our bill always includes all of our time as well, even if we're not billing for something. If a client stops in the office and quick asks me a question, or if they're dropping off paperwork, I don't bill for that time. I just think that that's nice. Because it would show up on the bill as a meeting with the client, and in their mind, they didn't have a meeting with me. I think billing is a skill. It's not one that people graduate from law school and have. So teaching it in a clinic setting is great. I wish I would have had that when I was in the clinic. So good for you guys for doing that and recognizing that that's something that needs to be done. Tips, I think the contemporaneous billing is probably one of the most important tips that I would give any new associate is do it right away. Start developing that skill right away. Maybe reviewing bills at the end of a case to see if there's patterns. You know, are you always billing a certain amount of time for a certain type of hearing? And maybe that's how long, I mean, in my practice, we do family law and criminal defense, so we're doing the same things a lot. We're attending a temporary hearing. We're drafting an affidavit. We're drafting temporary motions and orders, and they do tend to, you start to see, like, takes about the same amount of time. I know our support staff has developed a cheat sheet of approximate times, and that helps new support staff when they're coming in, if they're drafting something, to know it really shouldn't take you much more than, you know, X number of hours to draft, whatever it might be. And then I think for attorneys, also reviewing the time that their support staff is working on the case, so that there's a little bit of oversight there, is definitely important too. And not all associates have the ability to work with support staff, but if they do, I would say that's another really good tip. Yeah. We've got two. We'll go here first. Sure.
But I've learned the hard way, you got to you don't know when you're going to follow fees, or what you did, or like client will walk in and say, well, you've been doing a case, or we're going to do attorney, you can file a fee.
Right.
But I've learned the hard way several times is you got to try to figure out what you do.
So do you do it contemporaneously with your time then?
Like I said, I just maybe in the past, taking their intro comments, how long I worked on what I did. The basic, like I'm sure the insurance company problem with fees, can't really reveal the bill your hours 3 months later after.
Right. So the comment is about contingency fees and keeping track of your time, because you never know if you're going to have to collect on those fees or justify to someone else. Do you, as a practice, send that information to your client on a regular basis, or only as...
No, I don't send the regular people. I do probably 5.
At the end of a case, do you send it then?
No.
Okay. Yeah, I apologize for not touching on contingencies, but I don't have any experience in that area, but I do see the importance, like you said, of keeping track of your time for happy clients, right? Yeah. Okay, there's a question over here.
I'm just curious, what practice management software do you use?
We use, oh my gosh, it's going to, My Case. We use My Case. We used Bill for Time, and we used Tabs. Tabs was the first one. And we found that My Case was more broad. It had the practice management as well as the timekeeping. So one of the really awesome functions of My Case is that you can share a document with your client there. You can comment with each other. We find most of our clients still prefer just to email us, but there are certain clients that really like that the document gets shared with them via that program. It also then generates invoices for us and things like that. And you can have multi-users on a case, and you can give permission to, if you had a client who was 16 years old, you could give permission, if they allowed it, obviously, to, parent or guardian on there as well to look at those documents or contact you through that program. It's a great program. We haven't had any problems with it at all, but we've been through a couple. Any more questions, comments? Oh, yeah, we'll go here.
I was just going to have a comment. I'm in the more insurance defense side of things. So I work a lot of my billings based on what got bounced back. So going to your question, we have the insurance companies looking at what we've entered and really needing us to be descriptive. And so, if I'm reviewing medical records, I have to put how many pages of medical records I reviewed, or they can get bounced back for fairly low costs. But I found generally the more, as you said, descriptive I am in my entry, the less it gets bounced back. And so, as far as teaching people that, I think definitely I don't use abbreviation. I try and explain, like if I'm emailing a client or something, I'll say regarding and providing, and I'm giving them something.
Oh, that's good.
So I think I learned some of my practices based on what was, bounced back from the insurance companies, is what they said was fairly low cost, or what they said wasn't billable time. But I think generally, my bill don't get bounced back quite as much as some of the others, because I'm more descriptive in what I put in my entry. That makes sense. Is that helpful? It is. Okay.
Did you find certain things got bounced back a lot?
There are certain words, and I obviously, right now I can't remember them off the top of my head, but there are certain words that I learned to avoid.
Sure.
But the more descriptive I am regarding sections that I am providing X document, Y document, or if I'm editing something, saying why I'm editing it or what I'm adding in. If I'm editing discovery after I have the client, saying discovery based on information and materials provided by client in meeting. So just the more descriptive I can be, the better.
That's a great tip, is if your bill gets sent back to you. And I know some people submit their bills to the court, they're court appointed, and those bills could get bounced back too. One tip I heard from someone who was doing court appointment work was they were saying phone call with client's dad, and the judge said, I'm not going to pay you to talk to your client's family member. So, yeah.
Teaching a young somebody coming out of school that wants to accept the judges frown upon them trying to research something that all this common knowledge about. Obviously, these kids don't know anything when they get out of school, so they spend a lot of time. And the judges are sensitive with this, so trying to turn it as far as researching statutes or researching cases that you shouldn't have to research. If you don't accept it, you shouldn't need to research the definitions of it. And so they don't file unnecessary work. And I think that's a good warning to young people if they do want that.
And so that was my follow-up question, Susan, is how, in practice, firms compensate for the inefficiencies of their daily hired attorneys, and knowing that something that might take you 20 minutes can take 3 hours
Right.
for a first timer.
Right.
How does that translate to the client's bill?
So I think that's where review of a bill by someone a little more senior, and I do think there's value, though, in the client seeing, maybe I'm working on a case with a new associate, and I've tasked her to research an issue. her hourly rate is lower than mine. That helps, right? The clients maybe not feel so pained when they see that bill, but sometimes I'll put the time in and then I'll cut it. So if it took her an hour, and maybe me, I would have only had to brush up on looking at that statute. Like I haven't looked at it in a little while. Oh yeah, I remember, I'll cut it, but I'll let them know that she did work for an hour on it. People feel good when they see that on their bill and they like that. I am guessing most big firms have policies on how associates are supposed to bill and who's going to review those bills. At my firm, the bills are reviewed by the partner attorneys, and we review associate time and staff time, and we have the power, to cut anything. I always try to justify it, though, on the bill to show the person. But, to your point about judges not wanting to pay for things, thinking we should know them, I think that's just, it's kind of a sad state when our judges are saying, you should know everything about the Fourth Amendment and you should be completely up to date on the law, even though this big case came down, and you should know exactly how that's going to apply. So maybe that's where also being creative in how we're indicating what we're working on, or justifying it, saying, research on motion to suppress Fourth Amendment issue under new case law or new statutes, so that we're justifying to the judge or whomever, there was this new case. I could have never known this. This case just came down, or they just changed the law. I do some juvenile court work, and the juvenile court never wants to pay me more than an hour to meet with the kids on the case, and I have a case with 7 kids that I need an interpreter to meet with all 7 kids. Well, it shouldn't take you more than an hour to meet with those kids, and so I always put on my bill, interpreter present, 7 children ages 8 to 2, and try to and see if that helps. So, but I think it's a skill, and it's a skill that obviously we're all working on, and maybe is one that we could all use a little brush up on too.
I think the school is where that if you get over about 10 hours on the student, you have to run 5 hours about 45 on the student.
Right.
It's a fee basically. If you get over about 10 hours, it's going to raise some backgrounds.
Yeah.
On felonies, just federal seriousness. Not really, I haven't seen, I've never had a felony. When they got put back on this kind of thing back, this case that went to trial, and then was found out, the sale. Because it turned out that's the highest application I think they put in. And it's county, basically, a county's going to change out this notice. It really is not a very good excuse for it. The judge ended up paying it.
Yeah. Yeah. Another, you always hear these things, and people that do court-appointed work, you hear rumors, like, well, in this county, they won't pay you more than X number of hours or dollars. So those are things, practice tips if people are taking court appointments, talk to seasoned attorneys who say, yeah, this judge likes bills to stay under a certain number of hours or dollars. I remember when I started taking court appointments in Douglas County after being a public defender for 7 years, I was told you can't bill more than 2 hours on a misdemeanor unless it's a jury trial. At $50 an hour. Yeah. I said, well, I'm just going to submit my bills and see what happens. And so, yeah. All right, great. Good discussion, everyone. Thank you. I appreciate your time, and enjoy the rest of the day.
All right, everyone, welcome back. I am going to introduce Robert Brenner, our next speaker. Robert's going to be talking about practical legal drafting and discovery. Robert of Robert Brenner Law Office in Gering practices in the areas of ADR, family law, real estate, probate and trust, and workers' compensation, among others. He graduated from Creighton and is admitted to practice before the Nebraska Supreme Court, the U.S. District Court of Nebraska, and the U.S. Supreme Court. Thank you, Robert, for being here.
Thank you. Good morning, ladies and gentlemen. I have a topic to talk about is practical writing. First thing I get to do, because it's not Sarah's fault, is to apologize for the printed materials. If you find out what happens with your staff when you go to trial and you tell your staff to send it in, and they change it from WordPerfect to Word and just send it off. In case you haven't ever figured out what happens, it messes it up. I apologize if anyone needs a cleaner version. I definitely have that, and we'll be glad to send it to you. We're here today to talk about practical writing. And it's very important because it's the one form, a major form of our communication, both for our clients and to and from courts that we're going to deal with. Before I get going to the different areas, I want to talk about an overview on the organization that you should look at in practically writing things. First, it's important to have the facts and the law. You need descriptive headings because the descriptive headings will help both the judge in a particular case or the client see what it is you're talking about. It is better at all times and to help them comprehend what you're going to talk about. Take the time to present the order, because the order of things are very important. You must put the most important first. Every sentence in the way practical writing goes is to have your punch word or sometimes a phrase come last. You do not want the material to be in the beginning. Example, the guy acted like a psychopath because he was sitting reading a paper sitting in the airport. That's dull. Doesn't tell anything. But if you were to change it around, the man was sitting there reading a paper, looking on his laptop as a psychopath. You get more of a punch to it. You get more impact with the terms. Always draft, and I urge you to use, in some ways, forms. Now, there's a caveat to that. When we use forms, be sure you're looking at current forms, because many times we do have law changing. Obviously, always look for the correct grammar, punctuation, everything you're going to use, because remember, the reader, it doesn't matter if it's your client or the other attorney or a judge, will form an opinion of the author based on both the content and how it's presented. Remembering that errors in a presentation gives a negative impression. That impression carries on with the judge because the judge will not forget that. And it's very important to keep all of those in mind. So when you have substance, whenever you have, it's important to put the supporting evidence first to tell the judge what's there about. Be reasonable. And the most important thing that I've learned in my over 40 years of practice is that if I'm asking the judge to be unreasonable, something that would not fit an ordinary person asking them, you're not going to get a judge to go along with you either. A judge would simply put you in a lower priority. We'll look at it. Keep the requests simple and reasonable. When you have a paper, and I'm not talking about a brief this moment, if 15 pages of words can be done in 5 is what you should aim for, because the verbosity will not get you a judge's attention, nor will it get opposing counsel's attention, because a lot of times they kind of go real fast over a lot of that stuff. Letters are to be written to drive home a point. Pleadings, remember, are a mixture of plausible and law. Plausible facts and law. We'll get to that in a bit. Briefs are persuasive arguments. Persuasive. So to be persuasive, you need to have the punchline, and we'll go through some of the points that do's and the don'ts of that. One important thing that I have learned, and it probably is something all of you will at some point experience, that if you're going to write about the emotions of your client, that will not get you a result. Emotions do not get a judge to move. It just simply is not there. He's looking for facts in the law. He or she wants to see that. Keep the emotions out of it. So let's go first to letters. Let's talk about letters, and I will do it letters, then I'll do some pleadings, motions, and briefs in that order. In an overview of letters, you have, when you write a letter, you have a point or several points you want to make. When you do that, you choose and place strong words in an emphatic position. That's like I made the point about the psychopath. You have to choose where you're going to do it. An average sentence by maybe all the teachers I've ever had suggested we should always have it less than 20 words. When you start getting into a paragraph that's got that long, you're looking for what clause to what. It does not carry the reader. Remember, the reader is the important person. One of the things that we have to, at all times as lawyers, is be truthful. That is a characteristic that must be carried forward at all times. So when you're saying something and you're making a point, make sure, A, that it is truthful. B, that you are very careful on how you're phrasing it. You do not have an affirmative duty to educate the other lawyer, but you do have a duty to be truthful. That is very important because that carries it clearly within our rules. So one of the first do's on writing a letter is tell the truth. Second is reveal what is needed to make your point in the letter. Reveal what is needed. That's the point or points. If a particular statement is one of fact, depending on circumstances, say so. Be clear. Do not go into emotions. If you're saying my client has estimated the cost at $100, say so, if that's the truth. Now, always, and I've had it happen in 2 or 3 cases so far, where I have gotten a letter that obviously the other lawyer did not mean the words the way a settlement letter came to me. Because if it was, I'll take it, because he had it wrong on what he was trying to get across. Review a settlement letter twice, because a settlement letter will get you another event you don't want later on when you say it wrong. And that'll certainly make the client very mad with, why did we agree to that when they accept it? On a don't side, do not in a letter go into emotions. Do not let them respond and do it. One of the things that a don't in a letter is you get a letter from another person, a lawyer, whoever, and it's written with very lack of civility and professionalism. My best advice is to take calm, put it aside, because to respond immediately, you're responding with emotions. You do not wish to respond with emotions. You do not want that to happen. So when we go through it, we want to be sure that we use words. If don't use the words that has no meaning, there's nothing to it but to embarrass the other side. There's no point in doing that. It is not practical. It will not get you what you want. When you're writing to a unrepresented person, remember there's a rule in our ethical canons that is very clear that you don't indicate to them that you're a disinterested person, because you aren't. You already are a person who is biased, who has for a particular client. It's an ethical issue, and you must make sure of it. Consider the content and the necessary action. The basic, with what you're writing in a letter, it's as simple as an invitation. The who, what, where, when, and why. You're going to be looking at those. If it's a response, take the time that you've looked at what you're covering. Your point, clarity, truthfulness. Always be fair to opposing counsel. Sometimes they are not given accurate information. And I say that with tongue in cheek. We have that happen. You get one side to the story. You're telling this is what has been said. Would you confirm this or deny this? Let us know. Never make a false statement, because that will come back. Just 2 days ago, I got a letter from a lawyer that said that they had set up the insurance for this child, and it's all done. Amazingly, right before I left to come here, well, maybe we didn't, because we didn't have your social security number for the child. Why did you say it false? That I form an opinion of that attorney about how accurate he is revealing his information. Always render the candor advice. You should refer not only to law when sometimes you're having to write it. There are social, economic, and other issues, and you might address them, but do that tactfully and very short and to the point. Expressing comment about something, be sure that you're straightforward and it's candor. When advising, especially if you're writing to a client and you're writing them to tell them you don't have a good case. You don't have a case, and you've laid out why. I had to write one about a month ago, and I had to keep in mind how that person was going to react. This was a mother who lost her child, and she wants to have somebody pay for having her child die. And all I can tell you is you had to consider the morale of the person you're writing to, how they're going to receive it. Talk about social economic conditions, all the issues that you would approach. But be candid with purely technical information. I had to explain how the doctors had arrived at these conclusions. They're in the medical records, and I can cite to the page and tell them where it's at. But be very careful on that, because that can have a consequence. After she got the letter, she could call me and say, I really thank you. I understand it now. Well, that makes a big difference to the person when you're going forward. In pleadings, every averment of a pleading shall be, as the rule says, simple, concise, and direct. Keep in mind that there is one rule now in this and many of the states is plausibility. You must plead plausible facts. That does not mean I have to tell about he was a bad guy, he did this, he did that. Extraneous information like that in a pleading will not get you anything but a judge's ire on a strike motion. The pleading provides notice of what your claim's about, but you only have to put in some plausible facts with the conclusions. I just got done about 3 weeks ago. It was on a case having to do with the probate, and all the person did was recite the words out of the statute. The lawyer did. The judge threw it out, said it's dismissed. You didn't plead one plausible fact. You have to plead them, because that makes the difference when you do not have that said. Their pleadings are intended to end with the answer unless there's a counterclaim, in which then there will be an answer to the counterclaim. The language, terminology, the content of the pleading should be constrained to be honest, straightforward. It doesn't matter if you have 30 paragraphs, but if you have, and you get it only have 10 paragraphs and they're quite long, you lose the reader, you lose the judge, because the judge has got to look through that, and he will look through it, he or she will look through it. outline the order that you want to put your petition together. Be sure you do that. I've had several times that faced where they never pled jurisdiction. The person, I mean, an obvious thing to start with, why do we have jurisdiction? Venue may or may not be important, but pleading jurisdiction helps. When you are plaintiff or defendant, you need to plead citizenship, the residency. Just all you do is a short sentence to that. Resident of the county. That's all it takes. If persons are unknown, consult the statute. I just had one where they said, Mary Smith et al. That was the caption. You can see that isn't pleading what the statutes say. When you have unknown, it tells you exactly how to plead John Doe 1 or whatever you're going to put in there, but you would have them in there. You don't have et al. And when it went to the body of that pleading, it said and others. The judge pretty well eliminated and motion dismissed, granted, because you obviously do not have all necessary parties. So you see, that becomes very simple and very specific. One other thing in the pleading, you must be sure that your prayer, with practically writing it, that you've gone back up, what is the relief I want? Don't just say, give me relief. I actually had one like that a number of years ago, and the judge said, well, you didn't ask for lawyer fees, so you don't get them. You didn't get them. And that worked out to my client's benefit. Be sure that you get an accurate and clear portrayal of the facts. It's so much easier if you lay them out in chronology of order of events. Because then, like I had a judge a couple of weeks ago tell me, I could read that and go right down the line. I knew what the story was. I know what it's about. I don't have to have all the details. I've got enough to know the details. The do's on plaintiff or defendant. First and obvious is plausible facts. Be sure before you start writing it, you've done your research. Number one, you need to take a look at the elements that you would have for that particular cause of action. For myself, I have a binder that I have my staff, any of the staff members that have to look at anything, I have a binder on what are the elements. And I have it broke down by every theory I've come across. So by the cases that tells me it's these items must be pled. And we can go down the line and look at that. It becomes helpful when I have to go argue a motion because I can just grab that, take it, and I'm ready. Putting that together is very practical. Another example, the petition I mentioned about 3 weeks ago, it was pleading in a probate about undue influence. They just said, the daughter here was committed undue influence on mom and dad. That's all. Well, under the statute, under the pleading rules of the state of Nebraska, you must plead with specific particularity what facts shows the undue influence. That's required. That's not only undue influence. You've got fraud, misrepresentation. You can keep going. There's several of them. Duress, any of them. Any of them I can tell you because the probate area, there are several that all of them that they call, they're all having to have specific facts be pled. If there's a condition precedent, make sure that's clear that it was met or how it was not met, whichever is your situation. Enunciate it clearly. That's the practical. But before, again, doing any of the pleading, do the research so that you have your case. I had an example. I argued a case against a prominent lawyer about a week ago, and we were arguing about frivolous claims. They claimed frivolous against my client. And he says, Judge, I have the newest case right here, 2010. Now, we all know we're in 2017 and something surely has happened, which was the fun part. I said with my esteemed colleague here, I'm sorry, but he missed it. There's a case in 2013 by the Supreme Court that enunciated these are the points, not his language. And I can tell you, if you do the research, things like that, it didn't take long for the judge to immediately rule in my favor. But what you have is a situation of get the information, plead the plausible facts, don't plead innuendos. Don't plead innuendos. Don't plead that there's something else. If you have to expand the pleading, it would have been 2 or 3 pages to 4 to put in plausible facts, fine. But when you start putting in extraneous facts that are something else, you're going to find a motion to strike will be entertained. Do not fail to review the pertinent statutes. The example in probate areas, you've got to see if things changed, or if it's like we've had with contributory negligence or anything else, we need to look at that. So in conclusion, I urge you to outline the pleading before drafting, separate your cause of action, not theories. You can present alternatives, never insert anything dishonest, untruthful statements. It will drive you to having the reader not believe you. I know of judges who said, well, he's come in and argued and made citations to information that hasn't been accurate. Going to motions. In motions, the overview of that is a motion is fact sensitive. It's got to one point you're going about. There are nuances that may cause the judge to get different conclusions, so keep him narrowly to what you want to talk about. One primary point is that you're aiming to the audience, whether it's the client or how you're going to do it. It's critical that you do the motion and you address it. It could be outcome determinative to what happens. A good motion for summary judgment, an example that happens all the time. But if you blow it off, you're going to find out that's not a good situation. In drafting, in motions, plain and simple is the first rule. That's what you got to do. Make it plain and simple. A lot of motions don't need to have multiple pages. They can be very clear, but you do need to take the form that you're working from, rework it so that it concisely says if you're after a 12B6. If you're after that, indicate what it is that's missing, because the judge will look at what that motion is. Most of them I know, will have read the motion before they come in on the docket. And they're going to have read it. They're going to have looked at it. If they don't, they may say, I'll take it under advisement. Then they will look at it and think of what you told them. Use descriptive headings. Short and sweet for a motion when drafting is best. But I'm going to tell you the one thing that I have had happen several times. When a person just puts the word motion up there and nothing else, the judge says, what's your motion about? He put it in the title. If it's a motion to stay, if it's a motion of 12B6 we call it, or if it's I like it. In Nebraska, we got rid of special appearances back when we changed the rules. But I walk in and I had a case in front of a judge recently because I challenged under 2, 4, and 5 that there was not service of process right. The judge says, oh, Mr. Brenner's here in a special appearance, really. So we know what he's here on, because mine was in the caption. So he turned to the other attorney. He says, how do you show that he's wrong? I didn't take a but and that ended it. Because he had it when he came in there, the judge saw it and was ready. It worked to my benefit. But the don'ts are don't put any motions. You don't advance an unreasonable basis, and if you're asking for something that's unreasonable, the judge will see that the relief is not probably there. On motions, one thing over the last, I can say this, probably my last 10 years, I've learned one thing, that I didn't really see in the first 30 years. You need to file a response to a motion. It really helps because then the judge, when he comes in, is not saying, well, Mr. Brenner, what, are you opposed to the motion? He doesn't have to ask me a thing. He's read my response. Do a response. I'm telling you, unless you're giving in on it, then call the other counsel and judge will appreciate that you've done that. But do a response. Follow the same rules as I talked about in motions, but do a response. And I'm telling you, that will pinpoint the case. If you're the opposing party, you'll get the judge looking at what you're talking about. I probably for the last 6 or 8 judges I've been in front of, they totally love the responses because then they're coming in there, they're right back at what the case is about. They know what the focus issue is and that it's had a better result. And you can set forth the legal standard or the failure of an element or what it is that you can point out with the response. One thing on the don't heap a morass or a pile of stuff for the judge to expect him to read. If you do that, you just might as well have stayed home because every judge that I've had personal relationship with, every one of them tell me, Bob, I don't want to read all that. I mean, you go in for a summary judgment and the stack is 2.5 feet high. He's going, I know that's for the Supreme Court, but what about for me? So I can make the proper decision. Don't heap a morass. Just don't refer to the judge, well, you need to look at the deposition of Joe Smith. You need to have for the judge specifically the areas. Page 20, lines 11 through 15. Page 44, this, there. That judge will look to your stuff and see that you're more precise and practical. Your objective is to describe in general purpose the motion in short sentences. Keep in mind, you know your purpose when you start, my outline of what I'm doing, what the grounds are that I'm presenting, and if I'm referring to the affidavit of someone, say where I'm getting the content, not the whole material of what Mary Smith said, just Mary Smith said this. And it could be a short sentence. That will work very clear for what you can do on objectives of what you need to perform. Then to briefs. A brief writer's key function is to identify error and how that error is not harmless. It's reversible error. So if you're the appealing party, that's your purpose. So regardless of scholarship or legal, judges are ignorant of the facts until we tell them. When you have a judge on any kind of brief you're giving them, they are ignorant of the facts. They want you to give it to them in what they can take, not irrelevant facts, simple, straightforward facts. An organized statement of facts is a basis. I call it in my text a springboard for organized legal argument. Because if you do that, it is simple for the reader. If I got it in chronological order, I got it laid out nice, I have the emphasis of my sentences to the punch words, I have it done, I can do that. You need to blend the facts with the law. Now, I love what Judge Scalia, his comment was, the overarching objective of a brief is to make the court's job easier. I think every judge is going to say that he was right. They want you to make it simple so they can see it. Then they can expand if they need to look for points. I got a decision in yesterday on a case in which they could refer, because I had given them the citation to pages. They referred to the pages that I did for writing the decision. If I give it to them, and it was, the material was about 9 inches tall, but I cut it down so it's on 2 pages. Look at this page and line, this page and lines. They'll tell you about this, they tell you about this. That's all it took. I'm not saying the judge didn't read the whole 9 inches high. All I know is that he decided in less than 2 days. I don't think he read 9 inches. When you're the appellant or the appellee, first thing you have to point out is reversible error. If you're the appellee, how it is not reversible error. Know that, and I've heard this when I've been there up in the appellate court, Supreme Court, arguing cases. Counsel, we're not going to go through all that. Where is it that you're telling us? You don't expect us to go through all of that and find it. If you assign 10 plus errors in your brief on an appellate level, I have a comment, good luck, because 10 plus errors says there's some problems and you're going to have more problems because some of them are not going to be reversible error, if not most of them. There will be 3, 4, maybe 5, and that's what you need to do it. A complicated record needs to be dissected. And if you don't think you can do it, find somebody who can. It needs to be broke down to simple way of expressing it. Give the best reason for supporting or opposing your position up front. If you give your positions and they're all over the board, you'll lose the reader, the judges, because they're not interested in what you're going to present. I have found, and this has been very helpful in any of the briefs I've done, and I don't know how many appeals I've handled, if you present the facts in chronological order, they can stay with you a lot easier than jumping around. You have to do it in chronological order. The don'ts on the brief. The don'ts on the brief is don't have a recitation of facts in a disorganized manner. Just, you have to put it simple. That may mean you will shorten up some of it. Some of it you may be required. Your words may not be the best way of getting it across. You may want to use the words right out of what the witness said. To take it the old OJ, if it don't fit, must acquit. If you can use something as simple, it gets a point across. And that can be used. Don't mix facts, but place the facts in isolation to make the point. Always don't mix them up, because then they get lost. Somebody will not follow you. Always focus on what is the law and the point to be made. Do not get back to emotions. Emotions will do very bad for you. An average sentence is close to 20 words. That's the best choice in practical writing. Again, the advantage of writing shorter sentences in a brief is that you get more positions of emphasis in a brief than a long sentence to which they get lost in. Pay close attention to phrasing and placing strong words in emphatic positions. And I know that I've been guilty of the following, what is not a good thing in writing brief. Imagine you see a page on a brief and you see it bold in the middle of somewhere. What that is not good. Because what it is, the attention, the word there, and I missed the other part. So people, well, I don't get that. Turn the page. In other words, the reader is not going to get that. Do not use that. Don't end sentences that seem to drop off. You'll just have the reader brushing ahead more quickly. Never end a sentence with a date unless it's a surprise that you're trying to make the point. So don't end a sentence with a date. Also, don't end a sentence with a citation, because the citation is not the point of the sentence. You really practically, you want to put the bibliographic material in the text, and you can do it without having to have it end up at the end. I have seen many briefs that say, in many circumstances, or generally speaking. No, don't use those terms. Stay to your text, to your material. Avoid ending a sentence with the litigant's name. I mean, that Tom did this, at the end of the sentence. Don't end with that. Use that, like I explained, the visual emphasis sparingly, that bolding. You can use bold, you can use underlining, but be sure you're tactfully, it's not distracting the reader for reading the page. Consider the effect of boldfacing a word in a paragraph, because what they do is they catch that word and they jump around. So the important part when you're doing that is to see that with doing a brief, you need to spend the time. There's time to write the brief. It's not something that you should do casually. It takes time. You need to outline your brief as you would outline your assignment of errors if you're the appellant. If you would outline how you're going to make your argument. Many judges have urged that when you have headings to different parts of your brief, they urge you to make your point in a sentence that's the topic to that area. Because then they know that point, they can go right to it. It makes for an effective brief. It is practical, and it keeps the level of useless terms or the brevity that could be useful in making your point to the court. Well, that is, and I don't know where my time's at, 8 minutes. So is there any questions from anyone in this topic area? Yes, sir.
You had mentioned about writing letters to someone who might be pro se.
Yes.
I guess, what are your feelings when you're writing something to a pro se client? Where do you kind of have to watch that fine line between, I'm trying to explain this to somebody who doesn't have a legal background, and I can't I can't give them legal advice because they're not my client.
Right. And what you will do is be sure you do not indicate you're disinterested. That rule comes right out of the canons, okay? But what you will do when you write it to them, you will first emphasize that I'm not your lawyer, and I would encourage you to get legal advice. The second thing is what you will do is the law as it is written says this. In applying that law to the facts as my client has said it, this is how he or she sees it. We're asking you whatever relief you're asking for. Look how short to the point. I'm not telling them. Of course, start out with, I encourage you to get your own lawyer because that covers you for the canons. Okay?
Kind of clearly set out what's going on, but don't analyze that.
That's right. Lead them to it. It's just, that's there. This is bing, bing, bing. If you see any of this wrong, let me know. That way they have been able to see that that's what's presented. Anyone else? Any other questions from the attendees? Oh, yes, sir.
You had written advice for your letters to others considered moral and not social factors. Do you ever go so far as to kind of offer advice to those considerations, or is it kind of as one person to another just kind of do?
You really have to avoid, as he made the point, we don't want to be telling them, be giving them advice, because that would sound like I'm a little bit in the disinterested, but I'm trying to give you revealing information. I don't have to educate them what's relevant, but what I would do is simply, as my client perceives in this environment, this is the way he or she sees this should go. From a standpoint of, I don't know what the issue could be, an adoption, for example. adopting within the family deal. There may be a question about how right this is socially, morally, what it would bring up. You should, and again, advise them to consult with an attorney or other professional field.
More so, not necessarily as a pro se or party, but let's say your only client.
In my own client, I'm going to lay out the social, what I can see is these are some of the social values that I believe will come up. Let me give you, probably shouldn't, give you a good example. Years ago, I had a criminal defense case. The gentleman, multiple assaults. He was Hispanic. The assaults were on a number of Caucasian gals. And it was very clear, based on the jury pool, there were only 5 Hispanic family members in that whole jury pool. I told him, I think you're going to have a little problem. You were shooting at 3 Caucasian girls. From a standpoint of that, it's not going to look too good. I mean, and I had to tell him very upfront. So, and I wanted to make sure I had a record. So I had told him, you've got a problem. I think you should consider whether or not some sort of plea should be done because you shot the gun at him. And I had to approach the social economic. I mean, I looked at the jury pool and, the chance of us getting Hispanic on 60 jurors and only 5 of them Hispanic that are there, not good. Just a simple thing. In the end, he took a plea. It was better for him. I think he drew a year instead of what I think would be a gun trial. Some of the issues the police didn't know very well, so that was good. Any other questions from attendees? None? Yes, ma'am.
It's the basic thing, but when writing a brief, do you ever tend to use the person, refer to them by name instead of plaintiff or defendant?
Yes, it's much better to refer to them by name. Because when I've argued cases up before the Supreme Court, and I can talk about Mary did this, Tom did that, they then have to, especially if I'm on the side trying to sustain whatever I got, I want to get them to empathize a little bit with my side. Using names, I get somewhere. Plaintiff, defendant, I'm not going to get very far with what I think is sociologically.
So I do a lot of criminal defense briefs, and I usually use defendant, but it sounds more like, it's almost damning. It sounds damning to them when I call them defendant. Occasionally I'll call them
well, I try to use it in the beginning. I always put in the beginning mine, how I'm referring to them throughout the brief. And based on at least, I think my record, I like mine, that they've been able to get up there and, well, you pointed out that Mary did this. I knew they read it then. Because if I get the name to them, it's harder to be so cold about the record. Anyone else? Well, I think that takes us for a break. The next topic that they asked me to talk to you about is discovery under the discovery rules. I will tell you that another lady from Lincoln here, lawyer, and I recently redid the manual, the practicing manual on discovery. And if you were to acquire that manual, you'll find that section on discovery is what we generated, did the research, went through forms in it, and I would encourage you to look at that if you need it in particular. Discovery is one area that probably, even though I really do like trials, discovery is probably the fun time of mine, because I can find out the facts in the case even more than my client may realize what's there. The purpose of discovery, I've quoted from a case out of our Supreme Court, is to explore available and discoverable information, to find things, narrow the issues. I like the platitude. Great. But what it does is get me a lot of information. Litigation is discovery. A case depends entirely on preparation and discovery undertaken to complete that preparation. I want to go through, when I start doing them, I try to draft what is my strategic plan, how I'm going to do this case. Now, I will tell you that every case requires an independent consideration of discovery tools that you want to use. We're going to go through several of them. I'll give you some hints as we go through. Discovery is tailored to deal with contingencies. It's a compulsory process. Now, that's where in a while I'll talk to you about 30B6. It's a compulsory process where we get information. It's contentious, and some people get very upset. I have a client right now. It's over a house remodeling, and the defendant wants to go through the house. I can tell you the owners of the house are madder than ever because they don't want them in the house. It's contentious. So you're having to explain to the client, I'm sorry, you sued. This is what we told you in the first place. They're going to want to see it. I know it's been changed because it had to be fixed, but they get to come in and see the fix. That's all there's to it. Conflict can be avoided by knowing the client's case through thorough preparation. You know, when the client comes in the office, and I have a criminal case I'm doing now, I know the eyewitnesses' names, I know what they've said, I've got statements from them, and we're early on in the case. And when I have that material, they're believing their lawyer's working for them. They're finding out what's going on. It's a fact-finding process for the truth, and you want to narrow issues because you then get back to the motions because you can do it. Now, our discovery rules have now been put under a section 6, and they go from 326 to 337. And so we're going to talk about them. But understand, first of all, our discovery rules, and I can give you a volume of cases, say that we follow the federal rules basically. Now, I want to tell you something about how that isn't 100% there in a moment. The goal of discovery begins to prepare for any case. It is critical to develop an analysis of how I'm going to go forward in this case. One thing is clear. Every case can be prosecuted and defended with proper discovery. If you do it properly, if you find out your client's really dead in the water, you can then sit there, show the client, explain it to them, and whether it's criminal or civil, you can then get them to see a better course of action of where you should go with the case. Capture and preserve evidence. I can't indicate that enough. As soon as I get called in a case, I want to know about, have there been pictures taken? Have we got statements? Right away, think of the things you have to do. Because if you don't, in discovery, someone's going to ask about it. The speaker that's going to follow me is going to talk about e-discovery. And that is an area that is now becoming very important to how you handle things. One of the things that I have a fun time in, if you want to call it in the trial, is I use discovery to impeach the other side. I get to go after them for the facts that they are trying not to bring out. You get to use discovery to find out expert witnesses' opinions. You find out claims. You can ask contentious interrogatories. You can acquire the helpful information that will help lay out your case. And with all of that, you're all the time preparing for jury voir dire because you know the facts. I had a jury about 2 years ago, And the jurors told me afterwards that the three lawyers on the other side, and there was myself and my legal assistant, and the three lawyers on the other side couldn't seem to get the same facts together with because they had two defendants and they were trying to figure it out. But I could keep laying out how each one of them, what they did. And the jury said, well, that's why we rendered a verdict, because you had it to lay out. You knew the dates. So, but one of the things, as I mentioned a moment ago, the change in the discovery scope. Discovery scope has changed in that the scope under the federal rules has now been modified to a proportionality test. Okay? Now ours is simply under 326, and it doesn't use that word, but they are now in the federal talking and using a proportionality. In other words, I got a case right now, it's a probate. They're challenging, saying undue influence. And they are asking, because the will was made in 2008. They made up and served discovery that was almost an inch thick. An inch thick. And some of the questions in the interrogatories were, tell us everything you did for the 24 hours of the date the will was signed. Now, I represent one of the children. And I'm trying to remember what I did in a July date in 08. Now, as lawyers, we have our little books, we might know some. But you go outside this room and ask them what they did on a certain date in 08, or take your pick of any date. I can tell you it became useful because I went to the court and I said, Your Honor, we know it's not been adopted in Nebraska, the federal interpretation and the amendments, the proportionality test, but consider how sensible is it that this is this thick and we got an estate that's only worth $100,000. And there's maybe 50 in fighting about how much, what are we going to get? And then when I could read him some of these questions, immediately he could, okay, we're putting a stay on it. No discovery. Don't have to answer that. We're going to have to review what we're going to go into. Even though it's no adoption of the proportionality test, but the federal one has adopted. Now, the first area of discovery is informal. Now, I have used, and I don't know if any of the other lawyers in this room, I have used often social media to A, gather me information about the other side, B, use whatever information I can get on it against them in the courtroom. And I don't have to produce the pictures off their Facebook. I can phrase the question in a way that they think it's not harmful to them. But I get that you were there with your child at this location. Yeah, that's a bar. You were in a bar with your 2-year-old. Your picture is on Facebook, drinking drinks. The little child was sitting. Where was the child? It worked. But I'm telling you, I listed for you in the materials I've provided a lot of different things of informal discovery that I have a staff person generally do on most any of my cases. We go down the line, all the way down, trying to get all the information. We'll have folders on every one of it. If it's a criminal case or a civil case, I don't care if I'm fighting over a real estate transaction. I want to know everything about the other side, what they're telling about it. Maybe they have made arrangements to buy another piece of real estate and they want to back out of this deal because of that. I have to find out what's going on. Then we get to formal discovery. Basically, there are 5 areas that are to talk about. First, written interrogatories. Second, request for production. Third, request for admissions. Fourth, depositions, and that's including deposition by written interrogatories and depositions before filing of the action. And 5, subpoenas under rule, we call it 334A. Now, the first type that we have to do is informal. The second is this formal method. Now, the order of potential use of the discovery vehicles will vary. They will vary. I mean, I've had a case once that the man was obviously not in good health. I heard that when I heard not good health meant they said maybe a couple of weeks, and the action hadn't been filed. So I have to go through the process that we'll go through in a minute. There's different choices that come up. Now, in my case, I generally prefer written interrogatories first. And remember, written interrogatories, which I'll get to in a moment, is we have a limit that we can only serve. But I serve my basics to get me witnesses, experts, some of the information that exhibits, and get that out. Every case has to have that part at some point. I can tell you, if you go to court, you didn't serve those interrogatories, you get in the courtroom and you're surprised by witnesses, you may be surprised with another problem with your client. Why didn't you know that they're going to call this person? By not having inquired. So the first area I want to talk about is getting into doing the discovery. Now, I will tell you, I mentioned a little while ago about people that want to come into the house and examine the house. Now, I had another case where they wanted to examine the house and the property, and I got a protective order. It's under 326C for us, 6-326C. Get a protective order. And what that was, because the house wasn't in contention. They just want to be annoying. And the point of when I talked about practical writing, don't do things that's going to obviously be annoying. That was what the other lawyer was trying to do. And what it did for me was get the judge pretty well on my side, and we kept rolling along because they didn't get to go in the house. In fact, they were restricted to the area they could come on the farm because they were talking about farm machinery. He said, gentlemen, put the farm machinery in one little area. That's what they can go look at, period. And don't stray. And the comment was, I'm sure Mr. Brenner will be whatever the camera, so don't stray. Because he'll have a picture, and I will rule if you violate my order. A protective order is there, and it's useful to seek protective orders, even if it's, let me give an example. They want to get your bank statements. They want to get tax returns. I don't want my tax returns all over, my bank statements. You can get protective orders. You can ask them. Either they'll voluntarily do a protective order, or if they don't, you ask the judge. You're going to find a lot of judges very favorably will give you a protective order on the information to keep it constrained to this case and to turn it back when it's done, so that there isn't this material out there floating of your private information. Also remember, we don't have to give them, we can redact our Social Security numbers and that kind of personal information. So getting to interrogatories. First of all, we're limited to 50 unless you get permission of the court to go more. They have 30 days to answer unless they get an extension. The answers must be signed under oath. That is a problem many young lawyers don't realize. They have to be signed under oath. Not signed by the lawyer, signed under oath, unless it is an entity. If it's an entity, then that question can be signed in the situation. The next point I can make is in interrogatories, sometimes we have an objection. They're trying to get attorney-client information, privilege information, or they're trying to get something that you would assert an objection. Remember, at the end of the interrogatories, to put a heading, objections, and you sign where the attorney signs off, certifies that the objection's in there, he is made with valid reason. Now, my point is, the judges have been looking at that because that's written in the rule, and it's not been followed real religiously, but I've had a lot of judges lately note that if it wasn't, you didn't do it, your objection was over with. You don't have your objection. So they felt that you waived it. So I'm encouraging you to be sure that's there. You have a right to produce, instead of a long dissertation of material, you can attach business records with the interrogatory. I use the interrogatories to flesh out the necessary factual stuff I want, witnesses, persons, anybody with relevant information. The interrogatories should be flexible. You can't just, I think I have 5, maybe 8 that are pretty standard, and I can pretty well plug them in every one of them. But you have to be able to rearrange some others. For example, interrogatories can be set up to be contentious interrogatories. And what is your contention as to this? And you could take a part that they did in their answer or their complaint, and you ask, what is your contention of the facts for why you say that? You're entitled to ask that. Now, you can get the experts' opinions, and I'm going to tell you this ahead of time. At the end of every one of my requests for admissions, if you got a set from me, when you got to the end of the request for admissions, guess what you're going to see? An interrogatory, which says, for any of them you denied, I want to have the facts and the witnesses' names, addresses, and the names of documents that support your denial. I'm telling you, I have used that. I can't even give you how many times successfully that when they don't express it, they lose it. And it works out well. The next area I want to talk about is requests for production of documents. Production of documents, you need to really be very careful and get those very succinctly. I'm going to talk about in a minute about how you use the Rule 6-334 in conjunction with the deposition and with other requests. But it's important. They have 30 days to comply. The one thing I've seen many lawyers fail to do is to say, where am I to produce the items? Where am I to produce them? You must put down the time or place that you want them produced. Now, I had a lawyer in the last week here want me to produce what I call 2 storage boxes full of materials. She did not indicate the time or place. So I told her, your situation is you come to my office, tag what you want, you can get a copy. She sent me back a message, well, you just have your staff scan it all in for me. I promptly said, when you're paying us to do that, we will be glad to do it. Because the rule says I can do that. And so now it seems she doesn't want stuff. And it becomes kind of humorous, like, gosh, I had to get it all together because you made a request for production. And it was bank statements and every kind of statement in the world. And so now I'm not worrying about it. But be sure you request it. You don't need to organize the documents in any particular order for them. I had a case that I did about 2 months ago in which they wanted all the records. It was a trust fighting case. They want all the records of the parents that the trustee had gathered. She had them in 8 tote bag boxes. And so I told them, I got the 8 tote boxes here. I sent them a picture of it. You're fully entitled to come in and go through them. Those totes will take you about 2 days to go through everything that's there. And I can tell you, I opened up some of the totes because I'm also not gambling at what could be in there. And there were receipts from different grocery stores. There was everything. But they asked for this. I've complied, and the request for production. Be specific when you want some of these materials. The critical thing you have to tell your client right off the bat when there's a suit is don't destroy any of the records having to do with the subject area, because that could be considered spoliation. Years ago, I had a case in federal court in which I represented a motel. It was a discrimination charge. And they wanted all of the check-in receipts, all of the billing charges for your people that came to this motel for 3 years. I wrote the other lawyer and said, I've got 1 year They're in the large storage boxes. There's 10 of them. I have 1 year. I assume that that'll mean there'll be 3 times that because you want it for 3 years. You're at liberty to come get them. Well, they sat in my office. When we went to trial, they tried to make a point. Well, Your Honor, he didn't give us those records. Well, Your Honor, here was the picture. I showed him. And I brought the boxes in for the 1 year. I stood in the courtroom and the judge says, you're going to get them out of here. And promptly he says, well, I'm going to have to consider whether or not that's refusal to provide it is an instruction I may give the jury. Didn't matter. The jury threw the case out in favor of the motel, but it still was a situation that you can't have this stuff be gone. Then the next is deposition upon written interrogatories. Now, I've only done probably 5 in my career because, remember, written interrogatories has some lawyer sitting there helping them write the answers. So you really don't get the same as an oral deposition. But you would do it. You would do it in certain situations. Specifically, where I've done them is in custodial records. I want to get certain records from businesses, and so I want to get it. I can get a deposition. You're the custodian. These are the records. I combine it with the Rule 334, and I get both records, and I got the admissible testimony I need to put it in court. The procedure is outlined in my materials. Basically, you have to follow all the way down of telling them, these are my questions. They'll give you cross and then redirect, just like you would do in a deposition. The next area is request for admissions. The request for admissions is the one rule I really like because, first of all, I have no limit on how many I can ask you. 2, I can make these short, simple questions. Even the ones that says, you were negligent. You did this negligently. You did this. First of all, remember, requests for admissions are self-enforcing. I don't have to make a big deal at 31 days that you failed to answer them. 31 days and I got you. But I have no limit. So I use request for admissions, and I may serve. I just did the other day, I think on, someone asked me a pro se opponent. He got my pro se request for admissions. I think there were 89 of them. And I figured that he better read the rule, or as I sent him to him, get a lawyer. Because he has my request for admissions, and it's everything for our side of the case. And he's going to have a problem because I drew him up, took the time to make each one of them very short, to the point. If an objection is made to a request, it has to be stated. How? An answering party can't say, oh, I don't know. I've done that in depositions later on when I go, okay, you said here you don't know. What effort did you reasonably undertake to find out the answer? Well, I didn't do anything. I take that to the judge. My request for admissions deemed admitted. Under Rule 337, I get them admitted then. So it becomes important. And understand, whatever is admitted is conclusively established. But I'm going to tell you this, but let's say it happens that you fail to answer in the 30 days. You can make a motion for the court to allow you to withdraw the deemed admitted. And then you can put in your answers. I always, if I ever got, and this happened once, I put in what I was going to say. And that way the judge knew I wasn't just doing it to be annoying. I really had a good point. And it's been successful to withdraw it, but be sure you look for that. And if let's say you did admit and later on you find out it's not true, you can move to withdraw it, explaining that I want to deny it on the basis that I've learned this facts. It becomes important because requests for admissions can be used for the ultimate issues in the case. You can focus the case down. I usually use my request for admissions second after the interrogatories, and because I want to be able to do it. I have laid out in the materials that you should have for drafting them. I don't use any lengthy statement. If it can't be done in my sentence of 20 words or less, you don't have a good request for admission. Do you admit that? Those are the first 4 words, and the rest of it can be short. That's why I think I said 89 sent to that guy, because every one of them were short. It's just fact after fact after fact. Go for both contested and uncontested facts. That's kind of important. Now, getting back to the first thing I spoke today on was practical writing. I'm going to tell you, I have learned one thing that's important. I used to call it, you remember Jeff Foxworthy had, who's smarter than a 5th grader, I think it was, right? I use 7th grade language. Because if you use anything that's too much, you're going to find out that the people don't know what it is. And so you have to keep it very simple. Don't go for legalese, simple words. And it's very important to go down the line. You also can use requests for admissions to have admitted genuineness of documents, attaching them as Exhibit A, B, C, so forth. If they were in the deposition that you may have already taken, admit that it's genuine, what was Exhibit 37 or whatever. Go down the line. You can use the request for admissions to cover those. Remember, all of the request for admissions is self-enforcing. They have 30 days, not 31, unless they get an extension. When a person, the other thing that you have to keep in mind in request for admissions, which is what has paid me on a couple occasions, when a person just denied it and it was so obvious, after the trial, there's a separate proceeding for me to get sanctions, and I can get attorney fees for you failing to deny it or to admit it, whatever it was. I can get you for that. Then I get attorney fees. Do you know how that little at the end of the case really zings makes the other side go, God, we really got it. You know, we got to not do that with him again. And that's what's important. So you want to follow down under the rules is go down the line on the 336 and do it very carefully, go down the line. The next area, which I have only a few more minutes, is the physical exam is in controversy. If the physical person's condition is in controversy, the way I set up my motion for a physical exam is I've taken a deposition or I've gotten an interrogatory that's admitted that it's in controversy, and I can have a basis for a judge to allow me to have them examined by my doctor. A mere conclusionary statement and a pleading is not enough. You need some proof, some statement that says it's in controversy. And that can include a person even in the control of someone else. You can get it done. And it's important, you can use that for your case and how you're going to do it. The next area is depositions upon oral exam. There's a speaker going to talk later today about depositions, but there's a few points I would like to point out. And one of them is that you have to prepare for a deposition. I've had lawyers come in who I think they took maybe 20 minutes to prepare their client, and I'm going to take their client's deposition. First of all, that is right there a situation of malpractice. Because you have somebody who's prepared the other side, they're going to have the loaded questions ready. They're going to have a purpose in what their questions are. One of the areas I want to tell you about that I think is very important for practitioners is when you're suing an entity. The rule 6-330B6. That's where you can ask the entity to give someone who is knowledgeable on these topics to come in and give a deposition. I combine that through the B6 with the 3302 because then I can get them done. Bring the records the materials, and under Rule 6-334, I put them all at one time. You must bring them, have them here at the deposition, and I can go through them. And I had a case recently that the other side, a hospital, wanted to send in, I don't know what you'd call them, but worked in the claims part, the department, on answering about a bunch of the different policies of the hospital, having nothing to do with claims. It had to do with employment, this employment case. And they thought they could get away with it. And I'd go right down the line. Are you knowledgeable on this topic area? Well, you don't know anything about it? What about, are you knowledgeable on this one? Then you can go back under Rule 337 and can get sanctions. And there under 337, you have a possibility the judge could vary possibilities of what he could do. He could order, he could find them in contempt, which probably won't, but he could say they're pleading or that issue is established, which could wipe out their side of the case. The depositions upon an oral exam should be done after you've done your some discovery, because you need to have it outlined. I came across in the Trial magazine, it came out this month, they had a on-the-job training, a little article, one-page article about depositions, and it was written by this associate in a law firm, where she said, well, I've read a lot of deposition transcripts. I watch you take them. I've attended them. I practice good questioning. I practice being a good listener. I watched witnesses. I read books. I educated myself. I will begin with the end in the mind. I want to do them. That was her 10 points. My point to you is preparation should be done if you're the questioner. If you're not the questioner, I have laid out for you a number of important things you might go over with the client so that they're not nervous about the preparation. And I've indicated about the different things. Every time I've had clients, they're nervous, and it's understandable. I tell them, that's good. If you weren't nervous, I'd be scared. Because if you come in here and you're so confident, you're smarter than that other lawyer, and you can do this, I'm going to lose. Because it ain't going to happen that way. You're going to answer the questions, and there's going to be this. I go through this deposition preparation checklist with every client. There are videos, and I have them, where you can give it to them to take it home and watch it. I'm not sure how much that has ever helped any of them, but it's useful in some ways. But you need to go over the checklist with the client. The gentleman later today will talk to you about that material, and I want to be able to do it. When you take a deposition, there's no right or wrong, as long as you know your purpose and the major points you've written out and you're prepared. And if you're the attorney for the party who's being taken, you've gone over the major issues so that they understand its impact. It's very important to go through them. One thing in a deposition when you're doing it, which I have found, I can't stick to my script that I've outlined my notes, what I'm going to ask. I don't stick to the script because the witness may give the answer I thought as I thought of going through. Listen. Our biggest thing we need to do is listen. Remember that at the end, you can seek the deposition costs in this state for the original deposition, not the copy. So ask for that. There's several other rules that I've given you. Deposition Rule 334A is the one that I think should be used on a daily or frequent case because you get information from a third party. And the party can waive the 10 days, after 10 days serve the subpoena. I know that I'm looking at my clock and I'm already over. So is there any questions from attendees in the areas that I've covered? Yes, ma'am.
Mr. Brenner, where can we access the discovery and practice manual that you referenced at the beginning of your presentation?
Okay, I'm going to enjoy this. They told me it was going to be out here. I will tell you, Sarah said it was going to be out here. It consists of 379 pages. How's that? I don't even know how many pages. That's because when they sent it in to me after I got done doing my part and everything, had it printed off, and my secretary said, do you know how big that book is? And where am I to put it with? I buy a lot of discovery books. The form books, I have 3 rooms full of just shelves of books and organized by federal, whatever, state, procedure. And so it's kind of interesting, but they said, where we're supposed to put this? Oh, okay. We'll put this over with the discovery since that's what I know it by heart. Anyone else that I can help? Yes, ma'am.
That set of interrogatories that you serve following a request for admission,
Mhm.
talking about denial, is that considered one interrogatory that you hold back?
Yes, I always hold back that one. Remember, it's been my experience, if I shoot my 50, I can't ever, and I seem to learn something later on that I need to get another interrogatory out. So I never use all. I keep 4 or 5 in the end, but I know that's one of them, and I keep them in progression order. So that's my number that goes to that interrogatory at the end of the request for admissions. And I found a shortcut around the rule about interrogatories are to be short, plain, simple sentences. I have instructions. Instructions. The word detail means this. So, anyone else? Nobody. Well, I've used up my time and a little bit of the next speakers. So, thank you. If anybody tells me they couldn't hear me, I'd like to know. I kidded with them that I didn't need the mic. Most of the judges tell me to lower my voice. Supreme Court's even had to make that comment. So, you know, that's what I've learned this. So.
My name's Sam Delsenno with a company called D4. We do litigation support, and I was invited here today to talk about electronic discovery. So, Mr. Brenner, you talked about discovery in general. I'm going to be a little more specific when it comes to electronic discovery. So, real quick, just so I get an understanding, how many people in here get involved in litigation? Raise your hand. Okay. How many people in here on the more on the defending side as opposed to plaintiff side? What about plaintiff side? Plaintiff side, okay. That just helps me with some of the things I'm going to talk about. So, real quick, I've been involved in this thing that we call e-discovery or litigation support for the last 16, 17 years. Really, in the last 12 years, this electronic discovery has come around. And now it's discovery is overwhelmingly electronic in nature. I would say probably 5, 6 years ago, people were trying to get around it and not have to deal with it. But now, and I'll just tell you from a business perspective of the type of work we're getting, you just can't get around it. You have to deal with it. And you guys will all know that as you kind of go through your practice. So years ago, it was just paper, right? We would pick up, like he said, 2 boxes of paper. We'd look through it. We might copy it. We might make notes on it. We might use that paper. Now it's paper still. Paper hasn't gone away, but we're typically digitizing that paper, scanning that paper, right, so that we can use it electronically. Maybe we scan it once, and then we can make several copies of that and move it around, email it, organize it, whatnot. But a lot of this data, a lot of this discovery is electronic when it starts out, right? So we don't necessarily always want to print it to paper. Now that still does happen, but this data and this discovery is originating as electronic data. I was just thinking about this. I was driving over here. It's like my kids are getting ready to go to school here in a week or two, and so they're going to an orientation and whatnot. And I got a couple in high school and a couple of younger ones, but the high schoolers now, there's no paper. So at their high school, everybody gets a laptop, and there's no paper. at all. The textbooks are online. Their homework is on the computer. There's no paper. They carry around the laptop and their phone, and that's what they do. And so I was also thinking about the business I run and how much paper that I actually have to run my business. And there's not much. There's mail that comes in, right? But a lot of times it seems like a lot of bills that I have to pay for my business are electronic anymore. A lot of stuff that I send out is electronic. So there's not a lot of paper even in my business. And that's a lot of times who you're either defending or working with in some of these cases. So you got to think about where the discovery is and what the nature of the discovery. So I'm going to talk a little bit about, I don't have a lot of time, but I'm going to just give you a bigger picture, and we could talk about this for days just because it could get really, really kind of interesting if you really drill down in it and the stuff that we're dealing with. But I want to give you kind of some tips and tricks, practically speaking, because if I'm at a seminar like this, I want to leave with something that I can actually use. And so some of this stuff you already know, but sometimes it's hard to take it from the paper world into the electronic world, and they're really very much the same. So a lot of times when I'm talking with attorneys or corporate legal departments about their case and the discovery that they have, I try to bring it back to paper, a box of paper, because they can typically remember and know what that is like. And so electronic data is very similar. So first of all, there's a couple big items here. So when you're trying to put your case together or figure out the story, right, you're trying to figure out, all right, what pieces of the puzzle do I have here? You know, when you open that box and you dump all the pieces out and you're trying to find the edges and how big is this, first of all, how big is this puzzle? Boy, do I have a big enough table to put this thing on. Okay, where are the edges? Right now, let's start filling this in. You're doing a similar thing in this case. So whether that be paper or electronic discovery. So you might, here's a real life scenario. You might get a CD that shows up from the other side and full of email from whoever's involved in this thing. And you're like, now what? You know, how do I look at this stuff? I really don't care what the fantasy football picks were from last year. I really don't care about that. So you're very specific on what you want to see, right? And what you're trying to look for. And so what I'm talking about is kind of the scope of the case. And in that, we're trying to figure out how to be the most efficient in our planning as far as trying to put this puzzle together, this story, and how do we save the client money, because they're very interested in that. Definitely. So our corporate clients is funny because they ask me, they're like, who's a good attorney that knows how to do this, first of all? And number two, are they efficient in the way that they go about it? And when electronic discovery is involved, it can get very expensive if, you know, in certain cases. There's ways to save money, though, and a lot of that's due to planning. So first of all, when we get involved in this, a lot of times I'll ask kind of what's the size of this case? And really what I mean is, like, what is at stake here? You know, I don't need to know exactly how much money, but is this a smaller deal, a medium-sized deal, or a really big deal, you know, comparative as far as the budget's concerned? And I would say if you can get out early on these things, the better. The earlier, the better. Don't wait for deadlines. Don't let the court and the other side really set the stage for the timeline. You should be proactive in that. And it's like anything in life. It's like the sooner you get to it, the better, you know, you're off. And so figuring out basic things like, okay, what is going on? What's this, you know, what's the matter at hand? And then who's involved in this, right? So your custodians. And then what information might they have that would be pertinent to this case? And then where is that information? And then how are we going to get that information? So when you're thinking about electronic information, it's everywhere. Like, and I'll just give you some scenarios here of day in the life of somebody that may have some electronic information. So we're now pulling, you know, you think of e-discovery, you think of email. Definitely a lot of email, right? People type emails. There's emails going back and forth. thousands of emails. So that's easy. We go and find Mary's email, Tom's email, Larry's email, and we pull that email. Maybe for the last 3 years, we're interested in these date ranges, these search terms, we're looking for these things, right? It's pretty straightforward. Definitely kind of the clean, easy e-discovery protocol, I guess. It's typically not that way though, because there's other things involved now. So there's cell phones, which really holds majority, like if there was a case and you were going to need to get, and you could choose one device to go after to get information from, you would go for the cell phone. Everything's on that cell phone. And so we collect a lot of cell phones. Our forensic group comes in and we'll collect cell phones and search things like text messages, right, on the cell phone, emails, photos, social media that's hooked now to the cell phone. So you have social media now. So you have Facebook, Snapchat, Instagram, Twitter, all these things, and it's all discovery. It is interesting. A few years back, people would be like, well, Facebook is just too hard to like get your hands around and even look through it, and things change or whatever. But I'll tell you, the certain attorneys that are kind of getting that figured out are using that very well. So we can go in and capture a Facebook page. I'll just kind of explain some just specifics. It is now doable to go in and capture a Facebook page. Now that thing can be changed, it can be manipulated, you can take it down, but we've captured that in its entirety. And now we can basically fillet that thing down, put it in, basically make a database, if you will, and search that Facebook page. Some of these Facebook pages are huge. You know, if this person's been on that thing for 6, 7, 8 years, there's a ton of stuff on there. We can put that in an application now and search that, you know, because you don't want to spend 5 days trying to go through somebody's Facebook page. And that's very doable now. Same thing with Instagram, Snapchat. You know, it's like my kids have Snapchat, and I told them, they're like, yeah, well, the pictures and everything go away. And I tell them, well, you know, I'm in the business of finding those pictures, and we can find those pictures. They're not gone. They're not gone. And so now the harder it is to find it, the more expensive it is. It's just like with anything. But if someone really wanted to get that stuff, they could probably do it. Every situation is different. But, you know, I tell them, I'm like, I tell my kids, if you send a text message and you think you deleted that, it is still somewhere. And if someone really wanted to find that, you know, if you're putting stuff on the internet, you need to think to yourself, that's going to be there forever. And so now in the matter of law, boy, that really opens things way up now. Okay, so paper is one thing. Now this thing just went from black and white TV to HD TV because we have data all over the place, and there's a ton of places to go find it. So when you identify the people that might have that data, now you got to figure out where is it. And these are a lot of conversations we have with clients. They're asking us, okay, where are some of the places we should look? You know, we just had a case the other day, actually yesterday, where a truck driver hit a van and injured the person. I'm not sure the extent of it, but it was a truck driver's fault, allegedly. Now, the trucking company is saying it was the other people's fault, right? That was the fight. So the truck company called us, or the attorney for the truck company called us and said, hey, we think it wasn't our guy's fault, and they think it was. So we need to sort this out. So could you look at his cell phone? He says he was not on a cell phone when this happened. The other side's like, well, maybe he was on a cell phone, whatever. Yeah, so we're going to look at his cell phone. We're going to take his cell phone. We're going to image the cell phone, everything that's on that cell phone, deleted or not deleted. We're going to look for things like, we're going to look for activity in that time, what was going on that cell phone. Now, something to think about, and we were talking to the attorney about it, it's like there could be activities going on that cell phone that he wasn't a part of. So there's a lot of applications and programs running in the background that are happening, but he's not a part of those, and we could decipher those out. We can give you a report of this is the stuff that's going on, this is stuff that he was a part of, this is stuff he wasn't a part of. We could see, was he texting, was he on the phone, was he looking at a picture, what was going on? There's timestamps on that cell phone. And so we're going to put a report together, our forensic team, and they're going to give that to them, and they're going to say, this is what we found. And if it goes to trial, the forensic expert will have to get up on the stand and say, hey, this is how I did it. If you do it this way, you're going to get the same stuff. It's very important in this case because the other side is saying that they think that's what happened. And so that's just the cell phone. Now, if we have to go deeper, we told them, we said, all right, if that's not enough, they're hoping that's enough because they only want to spend that much money, right? Hopefully that's enough. If it's not enough, we can go deeper. We can get into the GPS system in the truck, and we can do some timestamp to that. All right, where was he? How fast was he going? All that stuff. We can put a report together for that. If he had a Fitbit on, we can put him at a place and a time. All these kind of electronic devices, you would be surprised. I mean, we're pulling data from all kinds of stuff. So that's just one scenario of the forensic collection side, but go ahead.
When you talk about that cell phone, do you actually take possession of that cell phone then? Or do you have possession of it before that person reasonably?
Sure. So, well, what we always say is get that thing as soon as you can. So don't let it sit around for 6 months. And, things are getting overwritten. There's a lot of things going on. You can get that cell phone as soon as possible. That's what you want to do. Just practically speaking, if it's an iPhone, we can probably grab that thing and get it imaged in a few hours, 3 or 4 hours. If it's a Droid or a different kind of phone, there's so many different phones now. Some of them take a little longer. It might take a day or two. People do not want to be without their cell phones. And so the cell phones are the hardest thing to collect on the forensic side just because they're changing all the time. So this company you heard of called Apple, they come out with these updates. Well, the reason why they're coming out with updates is they're trying to secure their stuff down, right? So the forensic people are trying to crack that open. They're trying to say, all right, we want to collect that and crack that open and look behind the curtain. So every time a new iPhone comes out, it's always about a version or two behind where we can still image it and get in there and look. But as those phones get older, it's easier to kind of get around them. So I would say if it's an iPhone, a couple hours. If it's more like a Samsung or a Droid or something like that, it might take a little longer. But basically, it would just be an image of the phone. And then once that image is collected, phone can go and do whatever it wants. The other thing, though, is if you can get the Apple ID, if they have an Apple account, which most people do. And I think there's more people with Apple account than Social Security number US. But if you can get their Apple ID and their password, we can download everything that's on that phone has ever been on that phone. And actually, that's really where the majority of the data is. There is some data on the phone itself, but if you can get that, that's great. If you're trying to get it from the other side, you might have to fight a little bit, but sometimes you can get that. Same with like Facebook and so forth and so on, if you can get their credentials. So does that answer your question a little bit? Yeah. Laptops are a little easier just because they don't change as much, but the cell phones are changing constantly. So that's a little bit about the kind of the collection piece, and that's your first piece, finding out who, what, where, why, and then you're putting your story together. And then once you collect that data, and I would do it sooner rather than later. So if you're anticipating, a lot of you guys aren't defending, but you're more on the plaintiff side. But if you're anticipating litigation, go and get ahead of that, because it's like, all right, a lawsuit has not been filed, but we know it's coming, and that might be in 3 days or 3 weeks or 3 months. Let's go and just secure this data and this documents, put it aside, and now we have it. Some people call that legal hold process, right? So that's kind of the fancy word for it. But once you have that data, now you can go back and look at that as you need to or whatever. The other thing is, the better you can understand the story and specifically what you want, kind of like what Mr. Brenner was talking about. He had those boxes of paper, and he's like, you guys can come over and look through them. Well, a lot of it's time versus money, time and money. Everything's time and money, right? So if Dan, the attorney, has 2 days, maybe he has 2 days, he can come over and look through that. Maybe that's worth his while. Or you might just say, you know what, scan the paper, send it over. I'm going to have Mary filter through this stuff a little bit, and then I'm going to look at it. I'm going to spend 2 hours on it or whatever. It may not be worth his time, to go through those boxes. Same thing with electronic data. So if you can get it a little more specified, you may not want my email for the last 3 years. You may say, hey, let's narrow that gap up. Let's get it a little tighter. Let's get these search terms a little tighter. We want to make sure we have enough, but not too much. And that's where you save a ton of money. A ton of money is on that collection of the data. So a couple tricks there are really there's the IT side, which is the technical side, and then there's kind of the law strategy side. And you really want to understand the technical side, but you don't have to be a technical person. You can use people that know about that, like people like me or IT people or people that are maybe it's an IT person within the company you're working for, your client. Really ask them a lot of questions. And so the preparation and the collection up front can save a ton of money on the backside. Here's the other thing. A lot of your clients will ask, well, how much is this lawsuit going to cost, right? Well, they all will. And it's like, you can't really say, I don't know. You got to come up with something. And so there's your time, there's other pieces of the lawsuit, and then there might be stuff that has to do with discovery, especially electronic discovery. And you can't just say, well, I don't know how much it's going to cost. So you need to put a plan together when you're putting that budget together, and at least to give them a ballpark of generally what it might cost. And that's something we do all the time. And that comes with figuring out who, what, where, when, how, and then kind of a plan on how you're going to go about it. And that's definitely doable. What I would tell you is a lot of people are scared of when they get a case and there's electronic data involved. They're like, man, I just don't know about it. You don't necessarily need to know about it, but if you can plan and put a strategy together on how you're going to, get through that data, that's all you really need to do. There's experts out there that can help you kind of manage through that process. But I'll tell you what we see a lot of. We see a lot of attorneys, we're a neutral third party, so we see both sides, and sometimes we're helping both sides just with their data or whatever. We really don't care who wins the case. We're just trying to manage the stuff, right? And we see this attorney come in, and I'll never forget this. This was like 3 years ago. I had to go to this meeting, and there was two attorneys in there, both sides, right? And this one guy who was in there, and this one gal. The gal had asked me to come, and she's like, just sit in and I want you to listen to what's going on, because we're going to hire your firm to help us with this electronic discovery. So I'm sitting in there and I didn't say a word. And this other guy had no idea what was going on. He understood the law, but this lady understood the law too, but she understood kind of the game or the strategy with discovery, and especially electronic discovery, and costs associated to that, and volumes and things like that. And I left there and I'm like, man, this guy's going to get his lunch eaten. And his client is trusting him that he's going to do right by him. And he does know the law, but he doesn't know this game. And so she ended up winning the thing. It wasn't even about the law. She won it easily because of the data, all the electronic data, and the way that she went about that. The cost was crazy, and he didn't even know what to do. And so the more experiences you can get with it, the better the value you are going to be to your client, to help win those cases, because ultimately that's what it's about, or to mitigate the cost or the risk, right? You're not going to win them all. So it's something that's important. I would tell you it's something that I would, if I were you, get around it, get cases that are dealing with it, get experience doing it. And the first couple aren't going to be perfect, but you're going to learn. You're going to, it's really going to expand your practice. And I'll tell you, we have a lot of different kind of clients. We have big corporations. We have big law firms. We have small companies. We have solo practitioners. Some of our best clients are just kind of a one-man shop who they've really figured out their niche, whether that be litigation or whatnot. And, they're just doing really well. They're super efficient. They know what they're doing. And it hasn't happened overnight. Like, we've been with these people for years. We've kind of seen the evolution. And even I'm thinking about different people within firms. They don't even have to be on their own. And the progression that they've had, even working with them over the years, it's been really interesting. The type of cases now that they're working on, and the wins that they're getting, and the knowledge that they're, and even to the point where I would not have recommended them 4 years ago, but now definitely recommend. I was thinking of one guy in particular. I had somebody call me, and I'm like, call this guy. He knows, and I'm like super proud of him because I know what he's doing. I know his, pedigree and whatnot, and he's a good lawyer. I mean, there's a lot of good lawyers out there, but he understands the efficiencies of e-discovery. And this guy is actually an employment attorney. So, but anyway, I would say whatever your niche is, as you learn the electronic side, and it doesn't even have to be litigation, but just how to manage your case, right? And a lot of times you're dealing with electronic documents. If you don't know about it or don't want to know about it, get somebody in your office that does. And it may be a younger person, doesn't have to be, but a lot of times these younger people they're quick to figure that stuff out, get a paralegal, secretary, whoever. And, they can really make your life a lot easier. There's some people that just don't want to deal with it, and then there's some that are genuinely interested, but you have to be aware of it. And then there's some pretty interesting, tricky softwares out there now that we use that can do some pretty crazy things. And I'll just touch on this. And if you're interested in any of this stuff, you can call me. I'm going to leave my card out here. So let's think about this. When you see, let's say you see this thing come across, hey, I have 1 gigabyte of email. What does that mean? How many emails is that? Well, if you were to print that out, it's probably going to be about between 30 and 35 boxes of paper. Everybody knows what that looks like 30, 35 boxes of paper, 1 gigabyte of email. So it doesn't sound like much, right? But it is. And so if you have an average person will have 2 gigabytes of email, 2 or 3, that's a lot. That's a lot if you were to print that out. And even if you're going to look at it, can you imagine? And you probably have to do that sometimes. So there's ways to go through that. So let's say you have a big case and you have 4 or 5 custodians and they all have email and they have 2 or 3 or 4 gigs of email. Maybe there's 20 or 30 gigs of email. 30 times 30. That's how many boxes of paper that'd be. And you got to get through it. You got to look through it. You got to make some decisions. You got to figure out what's what and what's going on. There's ways to take that electronic data. We can put it through the e-discovery process. We could search it down, clean it up, take all the duplicates out. Like when you forward an email and it's forwarded, and we can clean all that up. So you just have kind of the meat. And then we can put it in a review tool, electronic review tool. A lot of people use PDFs, which is basically the same as printing out the paper and writing on the paper. PDF, you're saving it as a different name. You put in this folder and you can't remember, okay, did I number it that way or how did I put it? It's a pretty clunky way to do it. If you only have a few documents, it's fine. But if it gets large, it's just not the way to go. So we can put in a review tool. There's review tools that people use. Basically, you log in. There's your images. You can organize them. You can tag them, flag them, sort them, produce them, number them. There's track of all that stuff. It's just the way to do it. And then produce them, at the end. And you might have several. You might have more data coming in, and you can organize it that way. But there's softwares now that, let's say that, what does somebody do when you have 500,000 emails, what are you going to do there? Or even 100,000. There's this thing called predictive coding. Has anyone ever heard of that, predictive coding? So there's softwares now that the courts will accept where we will, let's say we have all that email. We just did this with a firm here in Lincoln. It was really cool. Now they're hooked on it. It's not for every case, but certain cases works great. So we take all that data, we put it in this software. They're the chief reviewer. There might be a couple attorneys on this thing, but the chief person is going to review documents for 2 days or 3 days, and they're going to make decisions kind of like you all have Pandora. I like this song. I don't like this song. They're going to go through and train the software on how they're thinking. So the software actually starts to learn how they're thinking. The software is not necessarily looking for keywords. They're learning the decision-making process that this person is doing. And then the computer starts to put the story together on, okay, they like these kind of documents, and when it has to do with this and that, and they like to organize like this. So after about 2 or 3 days, then we run that through the software, and it runs all the email through it, and basically the computer makes a decision on this stuff's relevant and this stuff's not relevant. These are the songs you'll like. These are the songs you definitely will not like if it was Pandora. Now it gets dwindled down, way down. Now it's small, right? Now it's to the point where then that reviewer will go back in and spot check, do a QC maybe a day, and look at documents and says, okay, there's some stuff in here we need to tweak. We need to run it through again. Maybe we run it through the car wash again. And then they get it down to, okay, this is looking really good. And they'll actually produce all that stuff. And they haven't laid eyes on it, but maybe, 5% of it, if that. they'll produce it, not having looked at it all, but in the matter of, it would have taken them, millions of dollars and thousands of hours to review that physically, and nobody's going to pay that for this type of case. And instead they pay, whatever, and they can do it in a matter of a week or so. So, and the courts are accepting that. Some people are like, well, how can we trust that maybe we didn't produce something we shouldn't have or whatever? Well, when there's so much data and it's a certain kind of case, it makes sense. Some cases it doesn't. But there's softwares out there that do that. There's other softwares out there that early case assessment tools, which we use. And let's say you get a hard drive from the other side and it's just 100 gigs of data, and you're like, I don't even know what this is. Where do I even start? We can put in this software. It basically does an organization of the data, and it gives you physical pictures, kind of like pie charts or other graphs where you can look and you can say, oh, okay, here's a bunch of stuff that has to do with football. You can click on that, and then, you got college football, you got pro football, and then you click on that, you got, the SEC, you got the ACC, you got coaches, you have referees. And as you click down into that data, you get into the emails, and you're seeing emails between people, and then it charts it out into like a graph where, they got the center point of someone, and they're sending emails to these people. And you can see, and eventually you can see, every time the CEO emails his accountant, he also blind copies this other guy. Why is he doing that? And then you start to go into that, and you're like, oh, so this guy here, he keeps sending him this information about this. He must be involved in this. So you kind of get an idea of what it is that you're dealing with, right? So that's a case where you don't know what you don't know, and you're trying to figure that out. So there's softwares to help with that. And you don't have to know what all these tools are. It's kind of like when I don't know anything about cars, other than when the oil thing comes on, I got to go get the oil changed. So I take my car into my mechanic guy. He's got all these tools, right? And I don't tell him which one to use. He's like, I'm going to get this done. It's going to cost this much. When you come back, the car's going to be fixed. So you don't have to know what all the tools do, but generally I know what most of them do. I know he's got all the tools. That's why I take it there, and I know he's honest. He's going to help me. Same thing with e-discovery. Get people involved that know the stuff, that can help you, and I would say be proactive with it, and learn about it, get experience doing it, and get around it. There's two ways to obviously learn. One is by kind of the academic side. The other is by actually the practice of it. And so if you have friends that are attorneys, or if you have people that or opportunities where you can partner with someone, or even just try to do it yourself on a smaller case, I would recommend it. It's just going to add value to who you are as an attorney, and it's what clients need now. And it's only going to get it every year, every month. It's getting even crazier, And so, anyway, I'm pretty passionate about it. I love it. It's an interesting deal that I'm involved in, because that's all we do. We very much specific on discovery and electronic discovery specifically, but it's fun when we get to work with attorneys and paralegals and, the staff to organize a case in a way where they end up, whether they win or lose, they at least understand what is going on, and they have all the correct information. And it's a lot about the information, right? And knowing where it is, and what, a lot of times people lose cases because they're not prepared. They don't know all the information. They just, whatever reason it is. And the other side wins because they're a little more organized. So if you have questions, I'm going to leave my card outside. You can call me. I actually live in Omaha, Nebraska, but I'm up here a lot. We kind of go down to Des Moines and Kansas City a little bit out western Nebraska, but I'm available. So anybody have any pressing questions? Okay, thank you.